on. Defendant also stated she was operating the vehicle, but stated she did not hit anything and that the tire had just popped. Defendant stated she was coming from an influencer party. She had 4 shots of tequila, 1.5 to 2 hours before the accident. Officer observed slurred speech, the mild odor of alcoholic beverage, and defendant to be swaying back and forth. Standard field sobriety tests were conducted. 6 out of 6 HBN, 3 out of 8 walking turn, and 3 out of 4 one leg stand. DIC was read and defendant provided a breath sample. Results are 0.177 and 0.179.
Okay, I think that there's sufficient probable cause. So we'll have you sign all of the documents and after that you'll be free to go. All right. I don't.
was concerned about the wheeling. But
Yeah, I think there's sufficient. So I don't care what party you go to, do not use. Do you understand? Okay, good luck, man.
thank you.
Thank you, Mr.
All right, Judge. Next is page 23. Go ahead and sign. May, come on up. 23 and 24.
Did you want probable cause heard or did you want to waive it? Any prior DWI,
No prior DWIs, Your Honor.
license?
Your license is not eligible.
Okay, alcohol in the car?
No alcohol in the vehicle, Your Honor.
Okay, Mr. May, I'm going to find that there's sufficient probable cause. Well, I'm not going to find probable cause, but I am ordering you now as a condition of your bond not to drive. You do not have a Texas driver license and I'm ordering you not to drive. That is a condition of your bond and you will be signing an affidavit with me today. This is a promise and that you're going to swear to us that you're not going to drive. There's nothing in this life that you can justify getting into a car and driving. You do. It's really just not going to go well for you. Do you understand?
Yes, sir.
You are not to consume alcohol or illegal drugs. Likewise, if I find that you do, and I don't care what the reason is, you will go into custody. This is not a revolving door. If I have to put you in jail, you pick up a new case, you endanger my public. I will make your bond high. You understand?
Yes, sir.
You now stand charged with 2 cases. You're charged with driving while intoxicated. You're also charged with failure to stop and give information. On both of those, you're facing up to 6 months in jail and or a $2,000 fine. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you, likewise, your bond gets revoked. No more PR bonds. Do you understand?
Yes, sir.
All right, we'll have you sign all your documents and then you'll be free to go. Thanks, counsel.
Just over here, so you'll find his no driving affidavit. Mr. May, you can sign the license consent. Yes. Thank you, and I bet you I have your insurance. You swear to firmly you're not offering. All right, Jen. That's a driver's license and that case is open whatsoever. Okay, thank you. Next is page 20. Lazaro Reyes.
Did you want to waive PC or did you want to hear it? Waive it? Okay. Any prior to DWI's license?
No priors, Your Honor, and his license is eligible.
Okay. Anything aggravating?
There was an accident, Your Honor, there's no alcohol.
That's it. Okay. Mr. Lazaro Reyes, I am awarding you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or illegal drugs, or you're driving without a license and or insurance, then I will put you in jail. There will be no more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, likewise, your bond will get revoked. For now, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go.
Standard conditions. Standard conditions.
Standard, yeah.
That's it for now. All right, Jen, bottom of 1, Aguilar.
Hey, good morning, Luis. Mr. Aguilar, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Any prior DWI's license and
No cars, Your Honor. His driver's license is eligible and there wasn't open here.
okay. Mr. Aguilar, as a condition of your bond, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will put you in jail. No more PR bonds for you. I'm sending notice to DPS in Austin so that every police officer in the state knows if they pull you over and whatever car you're driving doesn't have an interlock, they're going to take you to jail. Do you understand?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria Center Reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go. Don't use alcohol or illegal drugs. Do you understand? I'm going to test you. If you use, you will, there's only one place. You understand?
Yes, sir.
I'm not asking you to split the atom. If you're going to drive, you must have liability insurance as well. If you don't have insurance, then likewise, no driving.
Yes, sir.
I'm not going to warn you again. We'll have you sign everything and then you'll be on your way. Please.
All right, Judge, next is page 6, Bell.
So, hey,
Bell,
Victoria,
yes,
on that one, can you generate? Um, please.
all right. Go ahead and have a signature.
You. You said this is Miss Alexis? What's your last name, ma'am?
Bell.
Bell, that's right, Bell.
Top of
It's
six.
Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. Where is this allegedly from?
Target.
Okay, stop. You're not allowed to talk to her, please. As a condition of your bond, I'm ordering you not to go to any target whatsoever for any reason. If I find that you do, I will revoke your bond and put you in jail. You understand, man? You were on bond for a theft. You're facing up to 6 months in jail and or a $2,000 fine. You understand? This is a condition of your bond. This is not, you have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're going to just try to use it to prove your guilt. Nothing you say at this point is going to change anything that's happening at this time. Do you understand? You have the ability to hire a lawyer. Are you working at this time? So I just want to know if you have the ability to hire a lawyer.
Yes, sir.
You do?
Yes.
Okay, we are going to give you time. In the interim, do not go to any target. Do you understand?
Yes.
Okay, that's not if, may, no. You go, I will revoke your bond. No more PR bonds for you. Do you understand?
Yes, sir.
Okay, for now, I'm going to have you sign a reset. We will have you take a seat in the jury box while we generate your bond conditions. Once you sign those conditions, at that point, you'll be free to go. And when you come back, please have a lawyer, okay? Please. That way.
That's the bond condition?
Yeah. So is that you or, oh, please?
Right this way. All right, Judge, bottom of 7, Brown, come on out. All right.
Mr. Brown, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case, not to be in possession of any weapons. There's a protective order that has been issued and you need to get to know it. Shh. If you violate this protective order, the state can and probably will file a violation of protective order. That's one of the worst misdemeanor cases that you can pick up. Do you understand? Yes or no? Do you have the ability to hire a lawyer? You do?
No.
How do you support yourself? How old are you, sir? Where are you a full-time student? Okay, how do you eat? You still need money, you still need, okay. For now, I'm gonna have you sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions ready for you. I'll have you meet with a lawyer here momentarily. Mr. Brown, I don't care what you need to do in this life. I don't care that you have kids. If you endanger my public, I'm gonna revoke your bond. I'm gonna put you in jail and I'm gonna make your bond high. I don't know who you have in this life, but if you don't have anyone to pony up 10 to 20,000, and you'll be stuck like Chuck in our jail. Do you understand? This is not a revolving door. I'll have you sign a reset and then we'll have you take a seat in the jury box. No contact and no.
Yes.
All right, Judge, bottom of 10, Dixon, come on up.
Take a seat for me in the jury box, mate. We need to reach out to Carl. This case is 450 days old. She's been MIA multiple times.
Top of 12, Herrera.
Okay, are you?
Yeah.
Great. Have you filed an attorney record yet?
Judge, I got hired on this last night, so I'll file one right now.
Got it. Okay. Do you want to hear probable cause? You want to waive it?
I'll hear it.
Mr. Ferreira, you're charged with driving while intoxicated. It is elevated. You speak English, correct? It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On August 16, 2025, in Harris County, officer responded to a crash on Turner Drive. Officer observed a Metro bus and Honda Accord. The wheel witness, the Metro bus driver, advised that the defendant rolled through a red light to hit the passenger side of the bus. Wheel witness advised she observed the defendant to be asleep. Officer observed the defendant in the driver's seat, keys in the ignition, motor vehicle in neutral. The defendant had a strong odor of alcoholic beverage and his breath, watery bloodshot eyes, slurred speech, and was disoriented and using the car for support. Defendant vomited twice in the patrol vehicle and as well in the ambulance, and officer observed an unholstered firearm in the console. SFSTs were not able to be performed due to the defendant losing consciousness. A blood search warrant was executed. The result was 0.23.
Oof. Any prior DWIs?
No, Judge.
That's really high. Mr. Farrer, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you as a condition of your bond not to drive any vehicle that's not equipped with an ignition or interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand?
Yes.
Does he have a license to drive?
He does, Your Honor. He's eligible.
You're not allowed to drive unless you have a valid liability insurance. You must maintain car insurance if you're named. If you don't have it, then no driving as well.
Your Honor, he drives a CDL, and he drives his personal vehicle very little. Basically, he's on the road all the time in the 18-wheeler.
These circumstances really scare me. Jose.
Yeah, no, I
mean,
I know that, Judge, but I'm not saying that to not give him an interlock, but I don't think there's a way for him to put it in the 18-wheeler. Could we do a portable device instead? Because he's not, I mean, there are going to be, 5-6 days in a row when he's not going to touch his car at all. So it's going to get
so
out.
let's do this. I'm going to put a scram so I know that he's not,
Okay,
and I'll pay for it.
all right.
But if I find that you're consuming any illegal drugs, and it includes painkillers, weed, anything, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
Yeah.
I don't care who you have next to you. You endanger my city. I'm gonna go bananas on your bond. You understand me?
Yeah.
All right, I'll have you sign a reset. We'll have you get with Veronica for your paperwork. So we're gonna file guardian interlock paperwork. So if he gets stopped, I don't know what's gonna happen with an officer. So
Can we write an exception into it for his work vehicle?
I don't know how we're gonna do that. Just think of something and then we'll talk.
Can we just add it to his bond conditions and then he can have his bond conditions with him?
I don't know. Let me talk to Ramon and see how we can figure it out.
Okay.
But I don't feel comfortable with all this. And he's got a CDL. It scares me to think that he's going to be driving a 10,000-pound missile regarding this. And it
He's got a
scares
criminal
me.
history though, Judge. And I
But this is, really just,
understand.
all right, let me have you sign all your paperwork and then we'll have you meet with Veronica for your bond conditions.
Okay.
But I'm okay with that fact, but he's got to have a scram first and then we can
Okay.
bypass that requirement.
All right.
Okay.
Thank you, Judge.
All right, Judge, bottom of 12, Fialo. Cardova.
Hi.
I am his dual guard, yes, my state, his IDD and all these things.
Or do you have actual paperwork stating that
I
it's,
do have it, I have a picture on my phone, and I'll bring the paperwork on me, I'm sorry.
do you speak English, Mr. Fialos? Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney appointed. If you cannot afford one, one will be appointed to you, sir. Okay, go slow, please.
On March 28th, in Harris County, officer dispatched to an activity call at an apartment complex. 5 calls were made to 911 after 10 p.m. that night. And upon arrival, the defendant was throwing items inside the apartment, turned his attention to his mother, and smacked her arm with an open hand, causing pain and redness on her forearm. The complaining witness advised she felt pain.
He had a prior assault about a year ago. Is this the same complaining witness?
It is, Judge Young.
Mr. Fialos, I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Fialos as a protected individual. Your mother is now protected with this court order. You cannot have any contact with her. Do you understand?
He doesn't have nowhere to go, he stays with me, sir.
Sorry.
I do take care of him, he does stay with me, I am his mom.
Oh, you are a mom,
I am.
and we're gonna have, so let's do this.
I am working, with the Harris Centers, trying to find him replacement due to his behavioral issues. We had, he's also with medication regimen, it's been kind of very hard. We had pneumonia after 2 straight months, was a lot of work, got out December 5th. And has been unable to get, back on a regimen, and it has been just off the hinges. I am his only parent, his father is deceased, biological father deceased, that father also deceased. So I am the only one that cares for him. And I devote all my time to him, I'm taking care of him. So at this point, I am just asking, I don't know, the courts can help me with him.
Let's do this. I'll appoint you a lawyer today, ma'am, but what scares me is that there's violent history
Right,
and it's,
aggressivity.
and it seems to keep continuing.
Right.
How do we,
I know, it becomes, just, I get it.
So let's do this. Let me have you, I'm gonna have him take a seat in the jury box for now. I'll have you just take a seat and then let me find him a lawyer and then I'll hook you guys up and then we'll figure out how to go forward. You're okay. Don't worry. Nothing's gonna happen.
This is gonna be good.
All right. Don't worry. You're fine.
No, I'm just listening to all
Yeah.
He's not gonna do things you're gonna put on himself.
All right. You can stay with mom. Don't worry.
He
Don't,
doesn't go by himself.
it's okay. You can stay with mom. Just don't leave. Okay? Vic? Thanks.
Next is Chapter 13, Foster, come on up.
Mr. Foster, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. I don't see a protective order that's been issued. Do you see it? Yeah. Okay, Mr. Foster, I'm entering now what's called a magistrate order for emergency protection that identifies Miss Whitty as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. This is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and probably will file a violation of a protective order against you. That's the capital murder of misdemeanors. Do you understand? You are not to have any contact and not to be in possession of any weapons while this case is open. Violate said conditions, don't. I will revoke your bond. I'm going to protect my community at all costs. I don't care who you are. I don't care how old you are. I don't care what color you are. You understand? No contact means no contact at all. We were going to reset your case to give you time to hire a lawyer. Do you mind filing those conditions, please? I'm going to have you sign a reset, then we'll have you take your seat in the juror box. Once we get all the conditions, we'll have you sign it. When you get a lawyer, then we can do it. But, all right, please, let me have you sign your docs and then we'll get you in. So no contact, no weapons, and then no.
Yes, sir.
Or I think we already have it, right?
Yes, and it's taken now.
Hmm?
I put it in your.
Does it say no contact? Or do I know to add? I have to add it. You want to print
It just
it?
says that.
And then I'll add it. Do you want me to still sign it or not? Sign? it? Okay.
You can find the printed copy.
Okay, so I won't sign this one. Okay, Victoria. Yeah.
All right, Judge, Chapter 14, Gonzalez, first initial A.
Ms. Gonzalez, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you now. Okay.
On March 28th, Harris County officer was dispatched regarding an assault call. Officer made contact with the reportee, the defendant, who refused to cooperate and was verbally abusive towards the officers. Officer detected a strong odor of alcoholic beverage and slurred speech from the defendant. Officer attempted to obtain the defendant's information from her mother inside the residence, but the defendant began to force himself in between and place her phone in the officer's face, asking them to identify themselves. Defendant was asked to step outside so officers can get information, but she refused. As the defendant was detained, the defendant began to resist by pulling away and swinging her arm in the air. The defendant's mother advised the defendant was assaulting her boyfriend outside the residence and advised that he was injured and had a laceration on his head, but left the scene before officers arrived.
What was she doing wrong initially that would prompt them to begin an investigation?
So they would dispatch the assault call, and when they were trying to get information from the mother inside the residence, she put herself in between the officer and the mother. Placed her phone in the officer's face, asked them to identify themselves, was asked to step outside, and continued to refuse to do so. And then when she was detained, she was pulling away and swinging her arm.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm not going to put any conditions on you. Just be careful. Do not pick up any new cases. You understand? You have the ability to hire a lawyer.
No.
How are you supporting yourself?
I work, as a bartender.
Okay. Now, how much do you make monthly?
No, it's just, good days and bad days.
Well, I need to know, so we can have you fill, no. I'll have you fill out an application. And I need to know everything about you. If you just put zeros, I'm going to send it right back to you. I need to know how much money you have coming in, any other sources of income, cars, anything of this nature, and I'll take a look to see whether you qualify. You have to meet the guideline. So let me have you sign a reset. Victoria will give you an application, then I'll have you take your signature. Deputy, do you mind? You got it.
No. All right, Judge, next is topic 16. Huh?
Good morning, Mr. Hawk. Sir, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. You understand?
Yes.
Do you need a lawyer today? I mean, do you have the ability to hire a lawyer? Okay, I'll appoint you a lawyer today, but you must show up to court. You must stay in contact with your lawyer. If you do not, I will revoke your bond. This is not a revolving door. You will not get PR bond after PR bond. You understand? Okay. Victoria,
Yes, Judge.
do you mind appointing him an attorney
Yes.
now? And then we'll just,
Free trial bond condition?
I'm gonna no alcohol, no drugs, random testing. So I'm gonna have you sign a reset. We'll have you take your seat in the jury box and then I'll find you a lawyer here momentarily. Come on.
Right this way. All right, Judge, next is page 26, Montoya, come on up.
Morning, Judge.
Are you here for Mr. Nanuna?
I am, Judge.
Did you want to wait? He's here. Do you want to hear
It's a personal history.
it? Okay. Hey, anything that we need to know about? Marla? This is Miss Montoya.
Particularly, Your Honor, no accident, no alcohol, no container vehicle.
License,
Running the license right now, Your Honor.
please. Miss Montoya, you're charged with, you speak English, correct?
Yes.
You're charged with driving while intoxicated. You're facing up to six months in jail and or a $2,000 fine. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. As long as you're not using, all will be fine. Because you have a lawyer, I will waive your appearance, but you must stay in touch with them. They'll tell you if and when you have to come back to court. If you're going to drive, you must have liability insurance in your name. If you do not, then no driving. That is also a condition. You understand?
Her license is eligible, Your Honor.
Great. For now, we'll just have you sign a reset. We'll have you sign your conditions and then you're out. Okay.
Thank you.
Thanks, man. Thanks, Daniel.
This way.
Confirmations are ready for you, fine.
All right, top of 27.
Judge, I'm going to say that.
Nicolette, come up, ma'am.
Go ahead and sign for your refund. All right, go ahead and have a seat up.
Ma'am, you are charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. Who's the complaining witness in this case, please?
Complaining witness is the homeowner, Your Honor. Defendant is the complainant's son's ex-girlfriend.
Okay, as a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You are not allowed to go where they live or where they work. Do you understand? If you violate these conditions, if you pick up a new case, I will revoke your bond and put you in jail. Like I've been telling everyone here, this is not a revolving door. You endanger my account, it's just not going to go well for you. You understand? How old are you, ma'am? Did you want to apply for court-appointed lawyer? Okay. Deputy's going to give you an application. I need to know everything about you, what kind of income you have coming in, sources of income, and then I'll see whether you qualify. I'll have you sign a receipt with Victoria, and then we'll have you take your signature box and we'll have you fill it out. Please.
This way.
And then if you can, no contact, no weapons.
Yes, sir.
I can't sign them. It's not letting me sign.
Okay,
Like, hold on.
Judge Singer was having issues with that. He was covering.
Okay, here, this one's signed. Let me see this. Okay, here we go. Here we go. Now it's one. Next victim.
Bottom of 30. Reyes, come on up.
Judge, also we're expecting a.
Okay. You are Mr. Reyes. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Any prior DWIs, license, anything aggravating?
His license is eligible, Your Honor. No prior DWIs. There was a crash, but there's no alcohol in the vehicle.
Got it. Mr. Reyes, as a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. You are not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance in your name. If you don't have it, then likewise, no driving. We are going to reset your case to give you time to hire a lawyer. So I'll have you go to Victoria, sign a reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go. Who?
Oh, Judge, he just signed on, Ruben.
Okay, let's do this. Let me have you sign a reset. We'll get you conditions so you can have all the paperwork ready to go. And then we'll just have you wait for Ruben to show up. As soon as he shows up, then we'll go forward. Please.
Right this way. All right, Judge, next is page 31, Samuel.
Samuels.
All right, Judge, top of 32, Sanchez.
Mr. Sanchez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. Anything aggravating?
Nothing aggravating, Your Honor, he was doing donuts in a pit of 100 to 120 vehicles becoming the closest.
Got it. Does he have a license to drive?
I'm running his license right now, Your Honor.
Okay. Mr. Sanchez, as a condition of your bond, you're ordered not to participate in these types of activities. Again, no racing, reckless driving, donuts, street takeovers. If you do, first, I will put you in jail, then I will take your ability to drive away while this case is open. Do you understand?
His license is eligible, Your Honor.
Great. How old are you, sir?
19.
What do you do for a living? Why?
I got fired from my own.
How are you supporting yourself?
DoorDash.
Okay. That is a job, but you need a full-time job.
Yeah, I'm working. I'm trying to create a fire.
Good. That would be great because you can make a boatload of money and that's what this life is about. The more money, the more fun this life is. You know what I mean? Right. All right. I'm going to have deputy give you an application. I need to know everything about you. We're going to, whether you qualify for a court-appointed lawyer, I'll have you sign a reset, then we'll have you take your seat in jury box and we get your bond conditions. And then after that, we'll have you talk to a lawyer. Come on.
Thank you.
And then if you can file those conditions.
Yes, Your Honor.
All right, Judge, counsel's approaching for page 13. Gomez, come on up.
Hi, Ron.
Hey Judge, how are you?
What's up, man?
I'm good. You
Did you want to waive
Yeah, we
PC?
can waive PCs, first and DUI, no accident, BAC.
Anything you need to know about?
No alcohol in the vehicle, Your Honor. Driver's license is eligible and no prior DWIs.
Got it. All right, Mr. Gomez, you're charged with driving while intoxicated and is elevated to Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, you will go to jail because I will revoke your bond. Do you understand? You're not allowed to drive unless you also have liability insurance. You must maintain car insurance. If you don't have it, then likewise, no driving. For now, we'll have you sign all the documents and then we'll have you get out.
Thanks, Judge.
Have fun.
Have a good day.
You too.
All right, Judge, that's it.
Any THAs?
Yes, Judge. Gomez,
Uh,
right this way.
Hi, are you ready?
Yes, sir.
Come on up.
Come on, Judge.
Good morning. Just the last name of your client.
Sir.
Just the last name of your client.
Hewlett.
I mispronounce all the time.
Hewlett.
Page 16, 17.
You make that jacket in 52.
Hewlett, come up.
All right. Mr. Lee, right.
Mr. Hewlett, you're on bond for DWI. You've now picked up a new case. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're charged with assault. You're facing up to a year in jail and or a $4,000 fine.
On March 29th, 2026, officer was dispatched to residence in Harris County, Texas, in reference to a disturbance call. Complainant advised that there was an argument with her husband, defendant, that defendants began to strike complainant on her torso area multiple times with a closed hand, causing her to feel pain and discomfort. When she tried to call 911, he
And then what?
when he tried to call 911, he took her gun away.
Got it. He's lucky he's not charged with another one. Mr. Hewlett, I'm going to find that there's probable cause to go forward on the new case. I told you not to pick up a new case. You've now picked up a new case. I'm now going to revoke your bond of the DWI. Sorry. Come, deputy. He goes with you. Sure.
Maybe we get the bond increased,
No. You're going to jail. You picked up a new case. I told you not to endanger my city. There's one place for you, and that's the only place I got. I'm not asking him to split the atom here. You endanger my city, and I told you once. He'll let her know.
Thank you, sir.
So I'll set the bond on, I'm not going to touch the assault but I'm gonna, at 5,001 for the DWI.
Yes, sir.
Okay, all right.
Thank you so much.
Thanks.
Maybe we visit later on, so once I get. I just got.
Sure, of course, absolutely. But I mean, he's going in. He
Yes.
picked up a new case. I mean, I'm not gonna,
Yes, sir. Thank you.
thanks.
Foster. Here, Mr. Foster. Mr. Foster, he's gonna sign for your bond condition.
Yeah, come on.
This one really That's
Yeah, chance.
So, bond conditions, please make sure you.
Bottom of five, okay, Jane, start calling up.
Yeah.
Ready? Come on up.
Yeah.
Morning, Mr. Banks. Do you have a lawyer today?
No, sir.
Okay, what are you doing about that?
Going.
All right, we'll give you, you don't need to say anything else. We'll give you more time. If you want to head on over to Victoria, we'll have you sign a reset and get you out of here. When you come back, please have a lawyer. Hey, you ready?
Hi.
Morning. Okay.
Give me a second. Last one was in 15. Blue on the 1.163. That's the bottom.
Cortez, come up.
All right, go ahead and sign, please.
Do you speak English, sir?
Yes. So I think it'd be helpful, we can help, but it might be helpful for legalese if we had a translator. Is that possible?
Yeah, of course. Yeah. You got to give me a little bit of time to get one, but yeah.
I didn't.
Well, but I need
We
him.
were under the impression he already signed my conditions, and so I just wanted to make sure. All right. Give me 1 second. I'm gonna sit down. I'm not going anywhere.
Okay.
So I'll stay.
Can you call a translator? Vic. Yeah.
Ms. Montoya, she has two cases. So we do normal process.
That's a mistake.
Just isn't ready for activities.
Thanks. Sorry about that. Okay, done.
Yes, sir. Judge, I have another THA.
Come on, bring
Top
it.
of 23, Manuel, come on up.
Good morning, Mr. Manuel. Do you have a lawyer here? What are you doing about that?
Well, I had lost my dog in this case, so
When is the last time you've had a full-time job? So how are you supporting yourself now? How are you supporting yourself now? It's time for you to step it up. And you need to get a full-time job. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and now 14. Have you had a court-appointed lawyer on every single one of those cases? Mr. Manuel, it's time for you to get a JOB. That is a condition. Do you understand? I'm going to bring you back in 2 weeks and I want to see what you have done to get a job. 30, 40 applications. If you've done nothing, you understand. Deputy, do you mind giving him an application, please? And then back in 2 weeks. As a condition of your bond, I'm ordering you, hold on. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs, and I'm going to test you like crazy. If I find that you're using, it's not going to go well for you. Do you understand me? I'm telling you now, I will test you within 30 days. You understand? All right. So, Veronica, testing, let's do 40 days. He gets tested. Yeah, I'm ready when you are. Carson, what was the last name?
Cortez.
Cortez?
Just to be on the safe side.
Right.
Yeah.
Are you waiving PC or do you want to hear PC? You waiving?
Written in a party, saw a minor accident, and he was there, didn't go off, it was riding test. By all means.
I don't care. It's up to you. It's up-
Have him read it.
All right, well, Mr. Cortez, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say, shh, can or will be used against you. It's like a zoo in here. I mean, what the hell?
On March 27th, around 1:30 in the morning, officer in Harris County observed a motor vehicle with front end damage and a flat tire in the ditch on the south side of the roadway with headlights and taillights on.
Hold on.
Officer approached.
Go ahead.
Officer approached, observed the defendant in the driver's seat. 18-wheeler on scene. Advised that the motor vehicle jumped the curb, landing in the ditch. Officer observed the defendant to have a strong odor of alcoholic beverage. Red, watery eyes, slurred speech. The defendant admitted to having 5 Coronas. SFST performed 6 out of 6 HGN, 6 out of 8 walking turn, 3 out of 4 one leg stand. DIC was read and the breath test conducted. Result for 0.169 and 0.163.
Mr. Cortez, I'm going to find that there's sufficient probable cause to go forward with your case. Does he have a license to drive?
There's no driver's license on file.
You are not allowed to drive. You do not have a Texas driver license. You will sign a promise with me today, Mr. Cortez. I don't care what you have to do in this life. If you do not have a Texas driver license, you are not allowed to drive. Do you understand? You will get a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you do, I will revoke your bond and put you in jail. You understand? Because you have a lawyer, I will waive your appearance, but it's your responsibility to stay in touch with Carson. If he tells me he cannot get a hold of you because you're playing games, I will revoke your bond. Understand that I'm sending notice to DPS in Austin. Every police officer in the state knows if they pull you over, whatever car you're driving doesn't have an interlock and you don't have a license, they're going to take you to jail.
Yes, sir.
For now, we'll have you go sign a reset. You'll get with Veronica for your paperwork, and after that, you'll be free to go.
Thank you, Judge.
Thanks, guys. Hi, Mr. D.
Good morning.
You ready?
I have a plea on Mr. Smith.
I'm ready when you are.
Yes, sir. Mr. Smith, step forward, please.
Good morning, Mr. Smith. Sir, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 12 days in jail with credit for the 4 days that you've done. You need to understand that this charge will go on your record. It will be there for the rest of your life. From now on, you will be facing a minimum of 90 days in jail. You understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. How do you plead to this offense? Guilty or not guilty? Are you guilty of this offense? Are you sure? I mean, you sound kind of wishy-washy. Because understand, this is a lifetime event that you do today. This is not Target where you can return it because you don't like it. I mean, once you plead guilty, it stays like this forever. You can never change it. Are you sure you want to do this? Your other option is you can, go to trial. But it's up to you. You tell me. Okay. I'm finding you guilty. I'm going to follow the agreement. I will send it to this. I'm going to waive your court costs so you won't owe anything. Good luck to you, Mr. Smith.
Thank you, Your
All
Honor.
right. Take care.
Yes, sir.
Victoria, do you have any more changes?
Yes, yeah.
Alpha 31, Judge Richardson, come on up. All right, Judge. Page 32, Sanchez.
We did that. Yeah.
Sepulveda.
Sepulveda.
Page 33, Smart.
All right, Mr. Smart, do you have a lawyer today? Have you looked to try to get a lawyer? What have you done? No, you're not answering my question. Have you done any research to go hire a lawyer? What have you done? That's not enough. You may need to talk to 10, you may need to talk to 20, you may need to talk to 30. 99% of the lawyers here in Harris County will put you on a payment plan for a couple $100 a month. They'll represent you. When you're talking to one or two, we don't give lawyers like it's candy on Halloween. I have a very limited number. You have to actually qualify. If I get a mother in here that's 6 kids destitute, just trying to put clothes on their back, and I'm at my last one, then you know what I mean? So if you're willing, if you're able and capable, then so we're going to give you more time. I'll have you go to Victoria. We'll have you sign a reset.
All right, Judge, next is 35 Stapleton.
Good morning, Mr. Stapleton. Do you have a lawyer today?
No, sir. I was going to ask for one lawyer. I was trying to get a lawyer. I gotta be,
Doesn't matter how much money it's the people of Harris County don't get to pay for a lawyer for you just because you spend beyond your means wearing a $500 Versace shirt and drawers, you know what I mean? Just, right, great, but nevertheless, if you're wearing $5,000, people of Harris County are not going to pay for a lawyer for you, dude, you know? Just people of Harris County are not going to pay because you spend beyond your means. This life is not how much money you make. If you make 5 million, but you spend 6 million. So, I mean, we will give you more time. 99% of lawyers here will put you on a payment plan. If you ask for a couple $100 a month, then they'll represent you.
I got.
How many, hold on.
I got a lot of calls going on.
Remember what I said.
I wasn't intending on pitching. Yeah, that's what.
I get it, Mr. Stapleton, this is number 1, 2, 3. How many court-appointed lawyers have you had prior to, right? Yeah, so now so we will give you more time. You need to start interviewing 10, 20, 30, and, right?
They're fine, sir. I'm not sure.
How many lawyers have you spoken to?
It's not that, it's just my job. I work for the Revocation. It's like.
How much money do you make a month?
It's not.
Don't, you know exactly how much money, don't play games.
We're not set.
How much?
I'm working with ships.
How much money do you?
Sometimes I might make, 4,000 a month, sometimes I might make 2,000 a month, sometimes I might make 22,000 a month. So it depends on.
You know exactly how much money do you make? How much money do you make a month?
I'm telling you, I don't have no set.
So let's do this. I'll send you home with an application. I need you to go to your bank account and you need to go every month. And then I need to know the average on what you make last 6 months. But we don't give lawyers like it's candy on Halloween. You have to actually qualify, meaning that you're making $15,800 a year. That's the federal poverty guideline, you know? So I just want to follow the law. That's all I want to do. I'm not. Right. Okay. We'll send you home with an application. When you come back, let me know, and then we'll go from there. But I'm telling you, we have to follow the federal poverty guideline. I hope you're not working and collecting unemployment because that's not. All right. Stop. Don't say anything else. We'll give you the information. Go home, fill it out, and then come back and then you show me. But I need to know on average what you were making a month, what you bring in at home. If you're making 4,000 a month, 6,000 a month, and this is a document you're going to swear to, do not lie on it. All right, come on. Ready?
Yes.
Hey.
How are you?
Hey.
I feel like every block up for tomorrow's Dallas.
Okay,
So we have two others that are setting court six. There is, I believe the court six one is older.
that's fine. Just go ahead, reset it. I need to do my taxes anyways.
So.
No, I think I'm gonna take tomorrow off. I gotta do my taxes.
You're just gonna do day today?
Yeah, just do 30 days.
Okay.
Yeah, it's not a problem.
Thanks so much.
Okay, hi, Clyde.
Well, how many months?
Okay,
We did the ALR on Thursday. I was looking at a certain issue. The officer.
the, none of that concerns me.
Why don't- I'm just-
What concerns me is how old the case is. You're now at 170 days. It's clear trial time. So I need to know what you want to do.
Well, they just put an offer in. He speaks a really strange dialect that was something from Afghanistan. I've got a translator here. I'm gonna meet with him.
Okay,
And such thing.
okay, but like I don't want you to come back in a week and say, okay, we want to apply for PTI. We need another 30 days.
It'll already be in. That's what he's going to do.
So I'll give you a week. If you want to do the PTI, are they approved? Do they need mitigation pack in?
No, there's no mitigation packet required. It's a point one breath test case, no accident.
Okay,
I just talked to them about that. And they can also put a time served offer as of today on this as well.
okay. So if you, we'll give you a week, in that week, come back, let us know if you want to accept the offer. If you want to do the PTI, it's got to be submitted.
Right.
And then we'll send them for a TRAS on that time. Okay, okay.
Your judgment, in arraignment with the interpreter. Page 29. Bam, judge, yes, all done.
Yeah, nice.
It's okay. We'll hit you up next, Michael. Don't worry.
All right, is that correct? Judge, say
What pay?
29. Oh, 29.
That's right. She said that, right?
All right, how,
Good morning, Mr. Pham.
yeah.
You were charged with failure to stop and give information. Shh.
Yes. Yes, Your Honor.
Can you hear better now?
Yes.
Okay.
Your Honor.
You're charged with failure to stop and give information. You were facing up to 6 months in jail and or a $2,000 fine. You understand the charges against you.
Yes, Your Honor, but how can I answer that?
You don't need to. This is why you have a lawyer.
Yes, sir.
The lawyer will answer for you.
Yes, sir. Yes, sir.
Did you want to waive PC or do you want to hear it?
We wait to see that.
Okay. Does Mr. Pham have a license to drive?
Auto insurance. We'll see that's from.
Is eligible.
Okay. Mr. Pham, you are not allowed to drive unless you have a valid license. You must also maintain liability insurance in your name. If you do not have car insurance, then you are not allowed to drive. This is a condition of your bond. If you violate this condition, I will revoke your bond and I will put you in jail. Likewise, do not pick up any more criminal cases.
Yes.
Lastly, you must stay in contact with your lawyer.
Yes.
I will waive your appearance so you do not have to waste your time coming to court. And he will tell you if and when you have to come back to court.
Yes, sir. Yes, yes, sir.
For now, we will have you sign a reset. I will have you take a seat in the jury box while we get your bond conditions. Once you sign those conditions, at that point, you will be free to go.
Yes, sir. Yes,
Do you have any questions?
No, sir. No, sir.
Okay, good luck.
Will you need to service as the interpreter or cannot do the translate the bond conditions?
No, I'm okay with you. The only other time we will need him is if there's a plea so that there's no conflict at that point. But other than that, I mean, from now on, I'm welcome with you interpreting, so we don't have to. Yeah, okay, thanks.
English for this pre-trial condition.
No, will you mind filing that, please?
And children have in custody of plea for MRP for Mr. Drew.
Got it, okay.
Michael license and insurance, right?
Yeah, no driving without a license and insurance. Okay, who's,
I have a. Please.
Bam,
hold on, let me do this plea real quick.
Ms. Drew.
Are you ready?
Yes, sir.
Coming up, Mr. Drew. All right, Mr. Drew, you were placed on probation for driving while intoxicated. Is it true or untrue that you have violated that probation?
It's true, Your Honor.
I'm going to find that it's true. I'm now going to revoke your probation. It will reflect as a conviction on your record. And I don't know how many others you may have, but a third DWI, it's a felony offense and you'll be facing up to 10 years in prison. I don't know, you made this, if this is number one, number two, I have no idea, number three, but this is an enhanceable offense. So if you continue to pick them up, at some point you'll hit a felony offense and you're looking at years instead of days. I am going to suspend your license. I'm going to suspend it for 1 year. Do not drive until you get a license. Thanks.
Thank you, sir.
Good luck.
Thank you, Your Honor.
Okay, guys.
Thank you.
So 33 credit for 7 and then 1 year driver license suspension and then, okay, Michael, you ready?
Yes, Your Honor. It's case number 26.
Oh. I just did the first one, so it's less work. Yeah. 1 second, let me sign this real quick. Okay, what is it?
2613724. Officer pass over the line.
Great. What, did they change this thing now?
Yes, yeah.
So where do I put the cost?
Right there, like I said, it should be.
The value? Okay, all right, Michael, what is it?
2613724.
Larios.
Yes, Your Honor.
Okay, what's the word?
Oh, I don't think that there's probable cause here, Your Honor, but I'll let the state do their. I mean, if you want me to tell you what they officer.
No.
did, right?
Is it on docket today?
No, it's on for Friday, but I figured since I'm here today.
I want to do it the right way.
Okay.
Bring your client here and then we'll get it done. I want to arraign them. I want to do everything the right way, just like everybody else. I know. Yeah. I'm happy to do it if
We
you
can
want to.
OPC it on Friday.
Okay, happy, or if you want to do it earlier, bring them earlier and then we can do it early. It's up to you, whatever you want to do.
Maybe we can do it tomorrow.
No, I'm not gonna be here tomorrow. I gotta do my taxes.
Well, never mind.
But Wednesday, Thursday, or Friday, you pick
Sounds
it.
great. Thank you.
Okay. Hi.
I'm approaching on Yana Williams. She's in custody.
Okay.
I'm approaching to see if you would consider lowering the bond in this case. Her booking date was 3/25, so she's been in custody for about a week. Well, that was correct. And I have reached an agreement with the state where they are willing to offer a kind of informal PTI where she's actively searching for employment weekly. And then if she does a job, they'll dismiss the case and at least over the next 3 months, if you would be willing to let her out.
Well, you said a bond reduction.
I'm
That's,
sorry, I'd ask for a personal bond.
I've given her already too. She doesn't show
I
up.
do understand that, Judge. I just, with this new deal, I thought I would reapproach.
But I understand, right, but we're gonna keep doing the same thing? Edge, can you bring out Miss Edge? Can you bring up Miss Williams, please? Does she have any criminal history?
No criminal history, Your Honor.
What is your position? What do you think?
I do have a concern about her not coming back.
Duh.
If we,
Well, Judge,
Of
I
course.
say every time she did come to court, that was before I was her attorney. So now that I'm involved, I believe we're
You know,
making positive progress.
I understand, but I still have concern.
Absolutely, Judge, I understand. And as I was kind of speaking with the state, I really do want to be a part of the solution here.
So tell me, have you met with her long? Who does she have in her life? Who's she gonna?
She is currently living with her uncle. She's unemployed. She is pregnant. And so like I said, I think her getting a job and being able to support herself is absolutely going to put her on a more promising trajectory. I will get the uncle's information. I will make sure I'm in contact with him.
Yeah, before we do anything, if I want to know that she's got a, like, I'm not gonna take her word.
No, I understand that,
Like,
Judge,
I
and
reach out to them and see.
understood. And she does not know about the new pretrial intervention deal, but the pretrial intervention deal is contingent upon you releasing
Sure,
her.
of course.
So I just thought I'd approach first.
Right, sure.
How's jail? You know, the funny thing is that it would only cost $500, maybe even less, to get you out. You gotta know that every time you go to jail, even if it's 100 bones, no one's going to get you out. Your lawyer's asking me to give you a PR bond. We have given you once a PR bond. You failed to appear. We gave you another PR bond, and yet again failed to appear. She's now gotten you a deal where if you just get a job, they will dismiss this theft case against you. Well, why would we give you another PR bond? History tells us what you're going to do.
I just dropped out of school. I had to pick up around with friends.
Uh-huh. Really?
Mama picked me out. I was homeless at the time. I just got back to school. I live in Montgomery. I just got back to school.
Why'd she kick you out? She asked you to clean the floor? Did she ask you to do something that pissed you off? And then you end up on the street? How are the streets? Is it better than living at your mom's house? Yeah, let me tell you, the streets don't get easier. The older you get, life doesn't get easier. You don't get more beautiful the older you get. It's the reverse. You lose hair. You start to, your body doesn't metabolize like it used to, so you start to go this way. It happened to me. I lose hair. I don't get smarter the older I get. Same thing. You have your youth now because you're young, but you're not going to have it forever. And the more conviction you have on your record, is it going to help? If you want help from the state, you think they're going to give it to you with a bunch of convictions on your record? You think anyone's going to give you a job if you have a theft on your record? No, because you're a thief. People will think to themselves, if I hire this person, what's going to happen? She's going to steal from me. Why am I going to give her a job? How old are you now? Miss Williams, the street is going to eat you alive. If you stay there, you're going to do stuff you never knew or never think you would have to do just to get something to eat. It's not a good thing. If we let you out, where are you going to go? You know that this person will take you? What do you think, Arwa?
I will post the PR bond if she has something to show.
I thought I would be.
And with this PTI agreement, the PTI agreement being in the direction.
And so everyone's gonna make good.
Look, talk to uncle, make sure she has a place to stay. I'm going to put a monitor on your ankle because I don't trust you. And I'm telling you now, you already have two. If you ever take off on me again, I will not give you another one. You take off again, it's going to be there until who knows when. And these cases could take damn near 9 months just to get a 911 tape.
Okay.
Do you understand? I'm not going to play this game again with you. You will be expected to work. You're not allowed to use alcohol. You're not allowed to use dope, and you will have a curfew because nothing good happens for a 17-year-old at 2 a.m. out. You stay out past 9 o'clock, it's not going to go well for you. You understand? You have one more shot. All you have to do is get a job. They'll dismiss this case. I don't know how much easier it could possibly be. Do you understand this, Williams? All we want you to do is not end up like another statistic or another woman have to rely on a man. Men suck in this world. You need to be a strong woman with a head on her shoulders so you don't have to rely on anyone for money, because this, if you have enough of it, will get you all the money in this world. That and this, if you have the heart, you can do anything in this life. But now you're at a critical state where you're either going to go this way or you're going to go that way. And now you're only headed which way? Okay?
Thank you, Judge.
Yeah, but first I want to know that you've gotten a hold of him, verify it, do a GPS prior to release with a 9 p.m. curfew. And then let's revisit in a week and see how it goes,
Thank you, Judge.
if you're able to verify it. Okay?
Will it be for morning time, 9 p.m.
6, yes, whatever.
Thank you.
You make me proud. That's all I want. Hey. What's up? Hi, Elena.
How are you?
Hey, pretty good. Just the last name of your client, please.
BUI.
Okay.
I'm approaching on the phone.
Great state of Texas.
So I'll preface this by saying that the demanding jurisdiction wanted this court to oppose a bond, but I told them realistically likely to go on. We won Allen Parish in Louisiana for worthless checks, but it is a significant amount. It's 60,000.
Wow, that's a lot.
It is a lot.
Holy moly.
So for 10 checks, the warrants from 2020. So because of the age of the case and the amount is that I would request a reasonable bond, that being 20,000, but also I don't know if the council has anything to say about his ability to self-surrender. So we're kind of.
Where's this person?
It's in New Orleans, Louisiana.
Allen,
I'm sorry, I said New Orleans.
Allen Parish, yeah, Louisiana, Allen Parish. So it's not far, and I've already reiterated they come twice a week, but he's still insisting on a bond, and he waived, so he don't withdraw.
Yeah, he wants a bond. He runs a business and he has no.
It's ironic because the business is partly how we got to here, just the bounce checks for 60,000.
Well, he's planning to, he moved here and he didn't get notice that outstanding.
Has the warrant been open for 2 years or did they just file it?
No, it's been open for 2 years, yeah, 2024.
That's a problem.
Yeah, he just said he moved out here, but,
Do you mind having, that you go and bringing him out and then we'll talk, Mr.
I
Booth?
don't have a problem.
Can you bring out Bui, please? Yeah.
The others.
I'll check it out.
Okay.
Because I haven't gotten any of those. Yeah, no worries.
And they were in, yeah, when you said that, I was like, what is on the other one said.
Okay.
But before I leave, I was first upon me, which was pretty.
It's gonna be out of money. That's my decision.
Yeah.
Yeah. Friday dates.
I was sent them printed out.
See, in this kind when I was.
What, you have something else?
Hey, you want to talk to me while we're waiting?
Yeah, I can send that one.
Talk to me. What's your cost number?
259.
Okay.
6090.
Okay.
Your Honor, upon this speaking, you have Mr. Riley, encouraged you. He understands that you're not gonna let him stay out all night, and like the ability to attend his prom.
Yeah, he can go to the prom, but I'm not letting him stay out all night.
I know not all night, the time with the court be called.
When is the prom? When is it?
Saturday.
This Saturday?
Yes, ma'am.
I mean, midnight?
Experience.
But that's it. He's got to be home by midnight.
That's.
Or the shoe. Cinderella, you know what I mean?
No, that's right.
Okay. Just for that one day.
Yes, John.
Okay.
That's all.
Yeah, so just let Ron. Good morning, Mr. Bui.
Morning.
Do you speak English, sir?
Yeah.
Do you want to translate it?
I mean, I've communicated with him. He understands where the warrant is coming out. I mean, I didn't have a problem.
So you are wanted out of what parish?
Allen Parish.
Allen Parish, Louisiana, for worthless checks amounting to around $60,000. Your lawyer is asking me to set you a bond, but I don't know. If this had been a new case, I would be more apt to, but the fact that this case has been open for the last 2 years gives me grave concern for you and that you're not going to show up.
Not really, see, when they send.
Let's not, I don't want to talk about the case. I don't care about the case. My concern is setting you a bond and you just going and taking off as opposed to going back like you were supposed to.
No, I go take care of that after I get up. Not problem.
And he has family here, you know, that are, that will assist with the bond and also ensuring that he's transported back to take care of it. He doesn't have any criminal history. He did not get notice of the warrant, else he's taking care of that. That's what he advised me.
Do you have any indication to know that he knew about the warrant?
No, you're not. But just due to the age of the warrant and the significant amount that is owed over the course of 10 checks, along with the age, is that a state requested a reason.
I'm curious. I mean, this is more rhetorical, but I'm curious as to whether those checks were all written at one time or were they staggered?
They were
to-
staggered, Your Honor.
So, I mean, you know, they also the recipient unless it's from,
Well,
I
no,
guess,
that-
different.
That would make it worse, Judge, because if it was over the course of time, the first one was kicked back before the last one. And so there would have been knowledge that,
Well, but don't they also have, you know, a responsibility to do some diligence to see whether, you know, that was my concern. as well.
different candidates, you know, but that's fair.
So what do you think about bond? What amount?
Say it wasn't a reasonable bond, he set in the amount of 20,000 to those factors. Anything other than that, I don't, he does have no history, that I can see. And so it's the only outstanding amount.
What do you think?
Your Honor, like I said, he is not a risk at this point. Even though the warrants are out.
Well, I'm going to set you a bond, but it has to be sufficiently high so that he knows that we're not messing around. I'm going to set you one, but they want 20. What do you think?
I think 5,000.
10,000 it is.
Yes, Judge. Oh, sorry. He needs to sign this.
Mr. Bui, I want you to understand something that I'm never going to do. I'm not going to do this again. You know, I give you one opportunity to do the right thing. If you fail to go turn yourself into Louisiana,
I'm gonna take care of it.
well,
Gonna get it.
just,
Gonna get it.
just listen. If you fail to go turn yourself in, then I'm going to set your bond at 0. I'm not going to give you another one. And the next time we get you, I will hold you until Louisiana comes and gets you. Do you understand? You have one opportunity. We give you, is 2 weeks.
Yes, Judge, 2 weeks. No,
We give you
first.
2 weeks from the date of your release to go to Louisiana. Do not wait until the last minute. As soon as you get out, you need to go there. You understand? Okay, has he already waived or did he?
He waived, he's withdrawing it right now. Judge.
Okay. Do you want me to go ahead and set it? Elena, do you want me to go ahead and set it now?
Yes, Your Honor. Yes, Your Honor.
Okay, guy. Well, I'm waiting.
I'll stand up. Thank you. Judge.
Okay, thanks.
Thank you, Your Honor.
Thanks, Elena.
Let me know.
I'm putting them right here. No. Oh, yeah, I'm sorry. I'm like, you feel what? Okay. Let me right here. Thank you.
Hi, Miss Henley. Just the last name of your client.
FRA. I'll come back to the. Oh, Miss Britton.
Is this the gentleman that was with Mom? Yeah.
Yeah. She told me to approach you on bond conditions.
I was initially I was going to say no contact, which is what we normally do on a second AFM, but I mean, I don't think that he has really. So we'll just do no harmful or offensive. I'm still going to enter in the MOA. So, and let the family know that they need to communicate to him that if he violates it, he's going to end up back in custody.
Yeah, I spent quite a bit of time just talking.
Okay.
Just now, and then I'm gonna reach out to Shaw, who's a social worker with, and she's also taught some about.
Whatever you need. I trust you. Just, it doesn't matter.
Okay.
Just, I'm happy to do whatever you want to do. If you want to set, you know, a month, 3 weeks, 2 weeks, whatever you want. Just, have you filed no threatening or harassing?
Right now.
Yeah, no threatening or harassing, no weapons. And then on the MOA, we'll take off the residential restriction and we'll take off the no contact. And then once he signs it, then you guys are good.
Yes.
Yeah.
I have something on docket. Do you want me to wait?
No,
All right, it's 2611265.
2611265 on,
She's a DWI over 0.15, but her conditions don't say she needs an interlock. And I hadn't told her she was gonna need one, so she went and got one.
did the magistrate order one?
These were ordered by me,
By who?
by you, and on her first one.
Did she have alcohol in the car?
She had an open bottle, an old bottle in the back. I don't think.
Is this the one she had like a half drink bottle of, it was some kind of hard liquor?
4 flatted tires
No.
and was across 2 lanes of traffic on an access road. But she's over 0.15, and so that's why I thought that.
I'm not I don't care about the number unless it's like really like a 3 or something, but
It was.
my concern more is if there's alcohol in the car or, well, that's probably the main concern, that or a DWI second. Sean,
I'm trying to find out, Judge, based on the connections too. Not seeing an open container in the car.
I just noticed, I watched the body cams, and I don't think the officers took it, that there was
I
alcohol.
didn't put an interlock on. I didn't put an interlock on, right?
You did
I
not.
thought you said I did.
No.
She thought you said you did.
And I checked her that there was no.
No, I didn't.
Okay. So
You're good. Yeah, just, you can go tell her, take it off.
Okay, thank you.
Yes, ma'am.
Judge, do you mind signing some conditions for Mr. Sanchez?
Counsel, you ready? Yes, come on.
On Miss Angulet Judge, NGO.
Okay. I think the only condition we did is no contact with the complaining witness, no going back. This is a mischief, right? Mischief? Yeah, just no contact with the complaining witness, no weapon. Yeah,
All right, thank you, Judge.
yeah, for sure. Ms. Jones, I'll hit you up next. Okay, Ms. Jones, you ready?
Yes, Judge.
Hey,
Hey.
Nolasco, come up. What say you, Miss Nolasco, or Miss Jones?
Yes, Judge, we're here. Today we were supposed to be preparing to do his sober court plea, but my client, as of last night, has some concerns about that. So we'll just address the BVR, and I'll need an additional setting to discuss with him what he would like to have happen with his case, Judge.
So you tell me about what you got on the BVR.
Yes, Judge. I believe there were multiple. One moment.
I guess we have not gotten a hold of Mr. Nolasco sufficiently. Nope, stop. Go ahead, Ms. Jones.
Yes, Judge. So the last BVR that I'm aware of, Judge, was the March 28th. There was some kind of temperate event reported at about 4:10 p.m. and that alcohol was detected. Confirmation was received on the 30th of March, Judge. My client has admittedly had some difficulty during this bond with his consumption of alcohol, which is part of the reason why the sober court plea was what
Yeah, I don't know
this
about
point.
you, but I just think that this is now a fifth violation, Mr. Nolasco. And you're not getting it. Nope. Look, a fifth violation. Over and over and over again. Deputy, I'm revoking his bond. You are going to jail today. It's done. Stop. There's nothing.
I'm gonna.
You're going to jail. I'm sorry. It's a fifth violation, tampering with the device, testing for alcohol again, over and over. I'm not letting him go just because he's supposed to do sober court tomorrow. I think that.
If I may, Judge, this is part of this is a large part of the reason why sober court is the disposition for this case, Judge. They have the tools to address the bond violation, the conduct that's leading to these bond violations in a way that's not purely punitive in nature and also disposes of its case, Judge.
I agree with you, Ms. Jones, but due to the amount of violations, due to the fact that he's got two DWIs and he's 19 years old, I think that more intervention than just sober court is needed. And it is now readily apparent that we can't even go, I mean, not a short period of time with the violation. If I let him go now, what do you think is going to happen in sober court? Within a week or two, it'll just keep continuing. And so I really, really think something more has to be done than just sober. I would say let's read in light of all these violations now due to his age. I mean,
Okay, I'll reach out because we just completed the TRX last month. I'll see if there's an agenda or something.
see, yeah, I just, it's,
Okay, I'll reach out.
Judge, am I able to at least get us a relatively quick setting on his case? I'm
well,
not
it's just
sure
going to
what.
auto-populate tomorrow regardless. If you want, we can put it on for Wednesday, if you'd like.
Yes, please, Judge.
And then we'll go from there. I'd like to try to do an expedited addendum to see if they, in light of all these violations, do whether they think that inpatient is more appropriate.
Yeah,
know?
Judge.
But I s- I mean, we're just, it's violation after violation after violation. It doesn't matter. It will just keep continuing.
I understand, Judge. I
Okay,
understand the court's position, Judge.
thanks, Ms. Jones.
Alrighty, Judge. May I be excused?
Yes, ma'am.
Thank you.
Bye. 50,000 and fine.
I don't look at your comments and look at
Victoria, anything you want to talk about? Okay, we'll talk to you later.
Conditions, no, the least of the, you do not have a here, you say, oh, you're killing me. Signatures, on the bench. Oh, Judge, Evelyn councils on moving from Bob 17.
Oh, Jesse. Bottom, you say 17?
Yes, Judge.
Good morning, Judge.
Hey, bud. Okay. What are we doing with Mr. Joe?
Capital Joe, we were going to withdraw. That's what you said for bond forfeiture, but he paid us. We are not moving to withdraw. I spoke to the prosecutor in court this morning, and he needs to work on a restitution writ. I know he was still required
Where's Mr. Joe now?
His car broke down. He couldn't make it today.
Okay, I'm gonna revoke his bond and I'll set it at 5,001.
Yes, Your Honor.
Okay, and then I guess we'll see if he shows up tomorrow or whatnot.
Yes, Judge. Thank you.
Okay, man. Have fun.
Have you excused?
Yep.
You just talk about what you read. Yes, so.
Here we go. Yes. You want to come with it?
And then whenever I got, it's like it's something, it's gonna work for the summer. We don't have to. We don't, you know, we have to. How does anybody else have them? But it has to be first. They gave me some money, so it's called. Give it to the health, whatever. I don't know. I have to do it, you know, it's like, we don't do it out. Yeah, probably pretty weird.
Any kind of. Already. I'm looking third for the customer service. So this is your next time. It'll be all matched. This is your witness. Here's our your excuse, you're gonna an excuse and then this is your conditions. You review this. Okay, so that's all. Yeah. And then you. Whichever is interpretation. That's the only difference. You're. This one, the best one to send it. Oh, yeah. All over the whole life. Yeah, you didn't get all of these papers. No. Okay. John, I have a bit of a special situation. I have the brother of a defendant that was having 2 cases here, and he was caught with the brother's weapons. They trying to retrieve a motion and order with the receipt of the gun, and he was trying to see if
You have the motion?
I gave it back, we could correct it, he has corrected a couple of things on there. And I haven't talked to the state yet, but I wanted to bring it up to you.
Okay, yeah, I'll give it to them and then.
And then, if you don't mind signing the conditions for Mr. Myers.
Yeah.
Never know you. Never know you.
How come you want me to unsign this plea for Drew?
So, stay on the paper, we only need to, set up documents when it comes to the MLB and MHA.
Oh, right, right.
And for some reason, those get pushed in.
No. Yes.
Okay.
Bios? Bios?
Good morning, Mr. Williams.
Good morning, Your Honor.
Sir, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 30 days in jail with credit for the 1 day that you've done.
Your Honor, I believe it's 10.
10 days.
Yes.
Oh, sorry, 10. It looked like 1. Sorry. I'm crazy. I looked at the slash mark. I guess that's that was one. It's 10 days in jail, sir. You're giving up the right to a trial, a right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it's ever like this. You can never change this. From now on, you will be facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
If you pick up another case, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
Do you still want to go through with this?
Yes, Your Honor, I'm going to be very careful not to let that happen.
I hope not.
I will not, I'm good.
How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement, send you to it. Good luck to you, Mr. Williams. Guys,
My judge, back again.
On this Griffin.
on who?
Griffin.
Okay,
I'm sorry, my hearing.
that's okay. What say you on Griffin? You want a bond?
Yes.
I am very opposed, if you wanted to. This is one of those, I guess you just hear from the court, but if she's available to come out. But she's one of her 6 charges, fraudulent use of ID with a mask. Grand theft
Whoa. Fraudulent use
of ID with a mask. I don't
with a
have,
mask.
I know, it sounds like an aggravated robbery, but I don't have the underlying facts, but she has 58 pages of criminal history. So I felt pretty confident coming in without the affidavit.
58
pages. So like I said, if she wants to come out, I can explain at least what she's charged me with.
You mind bringing her out?
That's fine. She don't know. She just wanted, she wanted to go.
I mean, I'm happy to talk to her, but
That's
I'm not
fine.
gonna, yeah, okay, so just ask Edge to bring her out and we'll talk.
Yeah, that's not a problem.
I'll stand it. Thank you.
Okay, thanks.
Or-
Ms. Alfaro,
I used to see in the
Okay.
paper.
hi,
Good morning.
Carlos. Good morning, buddy. How are you?
On this line, so we have Mr. Ramirez Castillo.
Okay,
Laces Ramirez Castillo.
No.
There we go.
so Do you speak English, sir?
Yeah, yeah.
Hey. I'm going to send you now for a drug and alcohol test.
Oh, he did that, Judge.
I already did.
And he tested negative.
Okay. If you ever miss again, you will go to jail. I will never do this again. You understand? Okay. All right, Carlin.
Thank you, Judge. Have a good day.
Have fun, man.
Wake County.
What was the last name again, please?
Griffin, Your Honor.
Good morning, Miss Griffin.
Good morning, how are you?
I'm doing peachy. So, ma'am, you are wanted out of the state of Florida, Orange County specifically for, you said it's 6 charges, 6 charges of fraudulent use
Oh, no.
with a mask.
No, that's just the first charge. She's
Oh.
also wanted for grand theft, third degree scheme to defraud under 20,000, fraudulent use of credit card more than 2 times, and possession of stolen counterfeit credit card. And I don't have the 6th one on me. They only put the first one for some reason on the count. But the state would be opposed to a bond. She has 58 cycles or pages of criminal history. In the last 5 years alone, and this is going in ascending order, failed to appear for a burglary, possession of burglary tools, criminal mischief, and a grand theft from April 2021, August 2021, theft 755K, December 2021, anti-shoplifter, possessing an anti-shoplifting device, organized dealing.
Faster.
Organized traffic, dealing traffic stolen property, grand theft 750 to 5K, theft third, which resulted in conviction, FTA twice on a burglary with assault, theft third, times 2, and a resisting from July of 2023. November.
Wait, this is just the last 5 years?
I'm still in 2024. I haven't started in 2025.
Should I set a bond?
I'm not the same person that I used to be.
That was 1.5 years ago to 2 years ago. And how many is that so far?
I'm only up to 2024. She has 5 more cycles in 2025, resulting in 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 charges, 2 of which are out of county warrants. So she's a fugitive before within the past year twice.
Should I set a bond?
Yes, sir.
With all that? The only thing I want in this life is I want my streets safe. And when there are 58 pages of criminal history, that's a lot. Don't you think? At some point, we have to say when, because did you have anything that you wanted to add? Yeah, you may say things, but paper tells us really who you are. And I'll tell you, Miss Griffin, it really scares me. So I really don't think if we were to set you a bond that you would show. So has she waived already?
She did. She waived on April 2nd. Pickup would be by April 17th.
Do we know that they're going to come
They
get
are
her?
very much wanting to come get her. I spoke with the coordinator, but I don't know if it's I don't know what the actual title is, manager, supervisor, but I spoke with the head. They want her.
Okay, regardless, we give them 14 days to come get you. If they don't get you within the 14 days, Harris County will release you. But you need to understand that these charges and the warrants out of Florida will always be there until you actually go back to Florida and take care of it. You understand?
Yes, sir. I was gonna take care of normal probation anyway, so I feel like it's taking probation with him.
Okay, just be careful.
Okay.
You get one life. You know what I mean? Sucks to always look over your shoulder. All right. Good
Thank
luck.
you.
Miss
Thank you,
Griffin.
Judge.
Thanks.
Judge, quick question.
Oh, is this for Carlos's case?
Yeah, it's 176.
Your case is old. What's the last name again? It's Lace, page 8. Okay. Do you have an offer on this case? Carlos?
I believe we do, Judge.
Okay.
And today we were just worried about the BVR. We were brought in early for that, so we just.
Great. I'll give you a week, but it's a clear trial at that time.
Yes.
So if you guys are interested in the PTI, it's got to be turned in by that next week. And then we'll see. Is he approved or not approved? Or I mean, does he need a mitigation packet?
So she's not gonna be off. Yeah.
Oh, is it okay,
It's
well,
talk for her.
got it. Okay, so just let me know in a week.
Thank you, Judge.
Okay, thanks, Carlos.
Some Joe release instructions that are in my pocket for.
I'll sign it for you. Just tell me to put it in.
Okay, thank you.
Wait, Mr. D.
Yeah, Mr. Saw, standing in for him.
Oh, you are? Okay, got it.
No, once I filed them, I was good with it, and waiver, I was gonna without it. Yeah, I'll actually.
Always.
This one's a little bit different. Possibly.
Sure.
It's 254.
254.
306.
Okay.
So he's been on probation since August 7th of 2025. He's been in compliance. But this happened before he got placed on probation.
Both of the charges happened before?
2009, and then the other one in 2016. But they
Goodness.
just arrested him
Holy moly.
on March 26th. So it looks like they were doing a long-term investigation, but the first offense happened August 1st, 2009, and then the second one happened June 4th, 2016. And I've already finished. Yeah.
I don't know.
Okay. He gets on probation in August. He has no more bigger impact policy. He's done residential IOP, SOP, DWI education. And he's $190 behind all three assessments to get this. He's in compliance.
I
don't know why I would switch to one.
Well, because a lot of
Yeah. Okay, we'll do, he goes to court on April 8th. I'll see what happens.
Let me do this. Hey, what's up?
She didn't show, she was a separate bond.
Okay, we'll revoke it. 5,000. Louis, hold on.
Louis. On the gym, or not on the show.
So, hey, top of page 21, 6001. Okay.
Are you in the courthouse?
Yeah, second stuff on nothing bad on you, but you need to talk about. Yeah, of course, of course. Okay. Okay. Mr. Lee.
Need to, approach, fill the need of Mr. On a client from Dixon.
Correct.
The net Dixon.
So
I understand that she's been gone a year. She informed me that she didn't know to come back and forth.
right, so we got to do something with this case. So, do you know when Carl can be back?
He's in Cancun now, so I would think that he'll probably be back this week.
Do we know when he's coming back?
You didn't say, Judge.
Do you want me to find out? Judge? I got his number right.
Do you mind? And then just ask him when he's going to come back and we'll set it for the day that he gets back here.
Okay.
And then they got to do something on the case.
Fair enough, Judge.
Yeah.
And then quickly, the defendant was the where George Lord they providing his ID and the receipt.
Guys, hi. Good morning.
Good morning, Your Honor.
Just the last name of your client, please.
JIRON.
What's your cause number, please?
2611881.
Okay.
He is here today with his wife slash complaining witness. They have been married. He got an we need a bond, Judge, because you allow walk through.
Of course.
I hear.
Yes.
You've got the bondsman, the Burns brothers are always here for me. You know, John Burns.
Yeah, of course. Who doesn't? Do you mind bringing, do you need a translator though?
No,
He speaks English, your client?
pardon?
Your client speaks English?
Yes, Your Honor.
Haran, come up.
Hey,
Your CW is here, so.
We spoke.
And the DA has spoken with her, Judge. She has indicated to them that she does not want a protective order. She does not want a no contact condition as part of the bond. They live together and have for about 11 or 12 years. And they have, how many children? 2 children. She obviously is the sole provider for his family. And
So
14
let's do probable cause real quick. So Mr. Huron, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 22nd in Harris County, around 2:30 in the morning, officers dispatched a disturbance call. Complaining witness on scene advised that her and her husband have been drinking and began arguing. The defendant used both of his hands and pushed her to the ground twice, and struck her with an open hand on her face multiple times, causing pain. And the complainant advised that the defendant and her are married with 12 years and live together.
Got it. Okay. Mr. Huron, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be tested. If I find that you're using, I will revoke any bond that we put on you and you will go to jail. Do you understand? This is not a revolving door. You will not get PR bond after a PR bond. You endanger my public, and I don't care who the hell it is. I'm going to throw your ass in jail, and I'm going to put your bond extremely high. As much as I love him, I don't care about it. I will throw your butt in there. Do you understand? I am going to issue a protective order because the protective order are things you shouldn't do anyways. However, at the behest, I will take off the residential restriction and will amend it to do no threatening or harassing contact. But what you need to understand, what is threatening or harassing is what she perceives. It's not what you think. I don't care what you think. So conduct, if I go like this, that in and of itself is threatening or harassing and can land you in jail in a moment's notice. Do you understand? The protective order identifies Ms. Hernandez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Do you understand? These are things that you shouldn't do anyways. And if I find that you do, and I don't care who starts it, I don't care how minute the argument is, I don't care whether it's about kids, I don't care whether it's about grades, I don't care whether someone pisses their pants, you do, I only have one place for you. Do you understand me? So let's set a bond. What do you think is appropriate? What do you think is appropriate? What do you want?
Judge, I would ask that you give the PR bond if there is financial circumstances. I said he supports 2 children and a wife, and he's living with 2 parents that he's assisting. He's living in their house, but he's paying in rent to help them get along financially.
What do you think? All right, I'm going to set your bond at $2,500. Mr. Huron, I want you to understand something, and I want you to hear me loud, and I want you to hear me clear. You will get tested for dope and alcohol. If you test positive, it's really not going to go well for you. Do you understand? I don't care what you're going. I don't care what you have going on. I don't care what party you go to. You use, you will go into custody. I don't care if she's using. You cannot use alcohol or illegal drugs. Do you understand? All right. I'll grant you your PR bond. I'll set the bond at $2,500. We'll have him sign the MOAP. He's going to have bond conditions that he needs to sign first before he goes, so that no weapons and no threatening or harassing contact that will outlive. I guess, well, he'll sign it. You don't need to sign it. You don't need to do it, Sean, because since he's going to be monitored for alcohol, then we'll have him sign over there. All right?
Thank you.
Have fun. Good luck, sir. Come on. Yeah. Okay, are you ready? This is your client?
Yes.
All right, is it Keish? Keiche, sir, you're charged with assault of a family member. You're facing up to a year.
I wanted to review, I just thought all. I should, but if it's showing that there's now, I'm gonna say these. So I'm forwarding right now, they're like, well, it's just a little bit kind of get out. He's the king. Yes. But I think just has to do.
So he just signed for deferred on a continuous family violence. Is this the same complaining?
No, it's a different complaint with the trial.
Okay, put her on the 22nd and let them know.
Okay.
Thank you.
Are you sure this is a good idea?
The one here, Your Honor, is minimal. My only concern is he has somewhere to go after this, it does.
My concern more though is that when you put too much on an individual, they tend to just get so overwhelmed that they just
Right. So that's-
implode, so to speak. And here,
I understand, Your Honor. That's why when I spoke to the DA, I didn't want him to have like double conditions where, because we don't even know what his conditions are for development. And he goes, because he has to do his TRAS. So I didn't want him to have.
so he has not done a TRAS there yet?
No, Judge,
How are they gonna put him on a deferred up there and they're not even done a TRAS?
Specifically on May, March, he been sitting in custody ever since. Next time, he told the probation officer, or someone in the board that he was homeless. So they haven't even provided him report instructions. They instructed him to report back to court, I guess, after this case was resolved.
I'm not ready to do this yet. I mean, I think that at the first thing that we need to do is the TRAS to see what, I don't want to set you up for failure. And here you are in the last, month and a half, you've picked up 5 cases, 4 of them being, all of them being extremely violent. And we're just going to throw you out to the wolves on a felony deferred and now another deferred on an assault, and you're telling people you're homeless? I mean, it's a recipe for disaster because there's a ton of stuff that you have to do. There's a ton of stuff that you have to pay for. You have to go to all these meetings. You have to do probably community service, a bunch of stuff. How are you even going to get from point A to point B? You know what I mean?
What I told you, Your Honor, he was homeless because he was living with his mother at the time. And that's the CW in this case. So now he's saying he has another family relative that he's going to do.
Okay, great. I first would like to do a TRAD to see what are the appropriate conditions that need to be, because something is going on with Mr. Kiche. I mean, for someone to pick up literally 5 cases starting in a span of just a couple months, something is going on. And I want the best thing to happen to you. I'm not just here to kill a case, to throw you out there with the wolves, because if you violate this thing, you're looking at a year in jail. You understand? It's not a joke. Not only that, if you violate on the case upstairs, you could be very well going to prison for up to 10 years. 10 years in prison. You have any clue what they'll do to you in a prison? It's a veritable nightmare in our Texas prisons. There's a lawsuit going on now just so they can get air conditioning. Just to get air conditioning when it gets up to 120 freaking degrees. Imagine what it's like being in a cage locked in with. So let's do this. Let's do an expedited TRAD. We'll set it off just a couple days, maybe like 3-4 days to see what they recommend doing with Mr. Kiche, and then we'll go from there. But
Okay.
a felony deferred this, and we don't know where he's going to go, how he's going to get the point. It's a recipe for disaster.
So
Thanks.
a 1 week, Your Honor, or?
No, I don't even think, do you think that, I don't know,
Okay.
you want to do this Friday? The latest Monday, but we can try to do it by Friday. It's just how busy they are, I don't know. But I want to do the right thing. And I think that this is just a recipe for disaster, really.
Right, we talked for a while because we.
Right. People will do anything and everything just to get out of jail without thinking of the long-term consequence. I know that you want to get out, but we want to do it so that you don't come back. Do you understand? So we need to set a real and good game plan, not just, okay, go, with the hopes that you get it done. You're what, 18 years old? 19, 21? Okay, without even the piss in. We need to sit you up. There's a lot of things that we can do, social services to kind of, all right? Okay. All right.
All right, thank you.
Thanks for being patient. Who's your last name of your client?
Lewis.
Okay,
Here for a reset. She has a job.
great.
She sent me emails that says, thank you, welcome to our team's time mark in Arlington. I don't know how you want me to show proof of that for it.
No, we'll just, as long as you're a lawyer, I trust you. I'm hoping that you'll recognize and, you know.
Yeah, she said, I've had multiple email background checks, all that. Great.
Okay. Yeah, we'll just give you a normal reset. Yeah,
Thank you, Judge.
for sure. Hey. Hey, can I borrow you for a second?
Yes.
Don't talk in the box. Can I show this to you?
Yes. Sorry. Did it paper? Oh, yes, sir.
I have a gentleman here that is trying to get a gun back. Apparently, it's not his, maybe like a brother, or I don't know. But it looks like there are two cases. There were out-of-county cases. One of them being a terroristic threat of a family or household member.
I'm confused.
Me too, because I don't know.
These are stemming from out of county.
No, they're.
Oh, they're from here. But you're saying in addition.
So, no. It looks like he may have been arrested on out-of-county cases. And they confiscated a weapon.
Oh.
And it looks like they're trying to get it back, but it may be the brother trying to get back the brother's weapon. I don't know. But I want you to see they filed this.
Okay.
And it's the gentleman over there. But I want you just to see it, and then I'd like your opinion as to what you think.
Yes, Judge. I'll need just 5 minutes.
Take your time. There's no rush, but I don't know what happened on those other cases. But if there's an open case with terroristic threat,
even if it was disposed, I want to check with them in the event that it is, because they wouldn't carry up the property. I'll check on that.
Yeah, thanks. Hi, Ruben. Just the last name of your client.
Varela Almanza.
You have a new case, right?
Is it, I don't understand your question.
You have it's a new case, right?
I definitely have a case. It's but you already dealt with one case. I'm dealing with a different, showing for another attorney.
Okay, what's the last name?
Varela Almanza. At jail.
That makes a difference. Okay. 2,410 days old.
Varela Almanza. So Judge Jacqueline, the office of Jacqueline Gonzalez, which I'm basically showing the counsel for, they did a training record, but it looks like the problem is that originally Marcos and Drogas office.
Yeah, it looks like Marcos. Mhm.
And so then they didn't submit a
I see,
substitution.
no, but I see that you guys did an attorney of record.
Right, so I'm wondering, could we be attacked because it was revoked?
They need a motion to sub.
So.
Do you mind reaching out to her and letting her know that we need a motion to sub? And then I can roll it to tomorrow.
Yeah, I could.
I mean,
I could
was-
tell her it's just that they gotta reach out to Rohit, to get the permission, to sign my permission. Because it was revoked, so that's why I was figuring like, usually we don't have to do that once it's revoked.
No. It's an open case. It's not an MRP. It's an open
No,
DWI.
it's cases, right?
No. It's an open case, right? It's not a KPS.
I mean, I show the last reset was from 2021,
A KPS,
and now he's in jail.
a KPS is meaning only a fine, right? Only
No,
a
I
fine
mean,
is due, so we
they
could,
they usually issue a KPS whenever it's like, okay, now there's a warrant out.
no.
They didn't put a
No,
warrant
no,
out
no,
for
but
this.
no. A KPS is for money owed. So let's say we have a guy that pled on a DWI, time served, and then he owes 6,000 on the fee, and he has not paid the fee. We will issue a KPS saying, hey, dude, you owe money. He's in jail, right? I can either satisfy it or I can make him sit now and do all 60 days worth of $100 that he owes per day. So this is an actual warrant because it's a DWI. He failed to appear.
What
So
about, it says alias KPS on the ones that's like,
I have no idea, but a KPS is for money
well, I
owed.
just
not
mean
because of-
that his bond was revoked, right?
Correct. This is right.
Well,
So
that's what I meant.
it's an actual
But usually when the
open,
bond revoked, I know when appointments, you can get another appointment without having to do substitution. That's what I'm saying.
this is an actual open case that's been in warrant status for 2,400 days. So we need someone to
just want to
sub
sub
in, right?
that's
That's the
fine.
correct way of doing it. I can't have, right? If it was a KPS pro fine where he would just owe money at that point, we'll either satisfy it or then we could do, but if he was on probation, right? Let's say Marcos put him on probation. At that point, yes, we would take him off because he doesn't stay with it. And then we would have you do the attorney. But here, it's an actual open case that never went away. The person never pled. He just took off and it was an FDA and failure to appear. So that's why we need the motion to stop. I may even have it over there. And if you want, I can call Marcos now just to make it easier for you, just to get the okay for you.
Yeah, I
sign my
mean, if
permission.
we could get, okay, I could sign for her. It's just, I gotta get to court 8. So I can.
It's up to you. I can roll it till tomorrow or you tell me what you want to do.
Man, if you could call and if you get the permission. And then I'll sign it.
Hey, you represented a guy by the last name of Varela. You signed on back in 2019. He's been AWOL. Yeah, he's been AWOL since 2021. Looks like he just got picked up. So the case is 2,400 days old. I've got Ruben, the struggler here is trying to sign on, but they need to do a motion to sub. Can you sign by permission with you? Okay. Okay, thanks, buddy. All right, take care. All right, you're good.
All right, thanks.
Sure. White cotton, come up. Sean, can I borrow you for a second? So this is Mr. White Cotton. Mr. White Cotton, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. It looks like there was a felony assault that just got disposed of on March 30th. Stop. You have the right to remain silent. We know what we're doing. Don't need your help. Is this a refile of that case or is this an actual new case?
I see that they're the same complaint witnesses. So, go check.
Looks like it was pled to 30 days on a misdemeanor, reduced from a second-degree assault. So what happened now? Let's do probable cause.
On March 28th, 2026, officer was dispatched to Bush Airport in Harris County. Complaining witness 1 reported that the defendant was highly intoxicated, walked up to him and punched him before demanding money. That complaining witness refused, and the defendant attempted to walk away, pulling the complaining witness's luggage, but was unsuccessful. Officer detained the defendant and transferred custody and control of the defendant to a second officer, the second complaining witness. The second complaining witness stated that he began walking the defendant towards the exit to place him in the patrol car, and during that walk, the defendant sat down and refused to move. The second complaining witness then took his hands off the defendant, who then stood up and attempted to run away. Complaining witness grabbed him, pulled him back down to the bench. The defendant then began twisting his body and kicking his legs in order to make that complaining witness officer release him. The officer continued to hold the defendant by his shirt collar and jacket as he laid on his back, attempting to keep him from moving. While holding the defendant down, he was able to turn over on his stomach, and he did. The officer's left hand was near his face, and the defendant bit down on top of the officer's hand, and the officer stated that he felt pain.
So which is ours?
So,
let's see, so that must have been, was the second degree the biting?
I believe so, Judge, and it does appear that these are the same. This is the same TNO transaction here. Let's see why it was refiled.
So you're telling me that he gets charged with a second degree felony and he pleads guilty the next damn day? For real?
It was.
Mr. Whitecotton, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. I'm going to put a monitor on your ankle so I know that you're not using it. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand?
Yes.
I'm going to protect my community at all costs. You put hands on anyone, I will put my hand all over your bond and it's not going to go well for you. You were forbidden from going to Bush Airport as well. You're not allowed to go back there. Do you understand? If I find, stop. I will appoint you a lawyer today, but if you go back to this airport, if you have any contact with the complaining witness in this case, I will revoke your bond and put you back in jail. I will have you, we will give you a lawyer. You can talk to the lawyer. At this point, you have the right to remain silent. Anything you say, they're going to try to use it to prove your guilt. You understand? Now's not the time. I'm going to do everything in my power to prevent you or to try to stop you from picking up a new case. If this means you not going back to Bush, then don't go back to Bush Airport. Do you understand? I will give you a lawyer. You can talk to the lawyer. We'll talk at that time. Vic, do you mind appointing a lawyer?
Yes, Judge.
Okay. For now, I'm going to have you sign a reset. We'll have you sign your conditions and then I'll have you talk momentarily to a lawyer. We'll go from there. Come on.
Is that a scram or a giant?
Scram. Scram. Does he have any other criminal history?
No, Judge, just these charges.
Okay. Nick,
Hey, Judge, how are you?
hey, what's up, man? Are you going to the game today?
No, I apologize for my tire. I just, something came in. Is there any way?
I am live streaming now. You want to talk him back?
Is that all right?
Of course.
Guys are like, that's. Oh, so.
And I'm sitting it here, I have to approach him on it, but I have to make a phone call, so I'll be happy, I just can't be recording with it.
Okay, that's good.
Judge Seymour,
Yeah, you said no cases.
That's it. But in the file.
No, I just, she just.
At all? Awesome. I kind of just go. Oh, you have to forget. But I'm looking for the copy. I want to make sure we put it all in. Okay. Yeah. I mean, it's just. Let's see. Yeah. So we're not. Because they will. I'm not sure. Discussing right now. I'm really going Yeah, I'd rather say,
Oh, I don't know. I'm talking. It's still, you see that.
White person? Yeah, okay. Okay, okay. Yes. Oh, yes. Yeah.
Mr. D.
413 is when Mr. Carr is coming back, Your Honor.
Okay.
On, Mrs. Dixon.
So, 413. You got to come back on that day.
Yes, sir, Your Honor.
Okay.
Thank you.
Do you have any conditions until then?
Just come back.
No.
Just come back. Okay. We're good to the list? Oh, I'm sorry, Martin, you're still there.
Yes,
Next
sir.
one, Gail, man. Okay,
Sorry
hold
about
on.
that.
So last name is Hannah?
Yeah, the first one's Hannah. I did try to call to the holdover cell, but I didn't get an answer. But I mean, PC wise, I'm not.
Etch, you got Hannah back there? Can he call over there so he can talk to him? All right, try again, Martin.
Yeah, PC wise, I don't want to. I mean, there's nothing that I can challenge on it. So I'm sorry I'm not there, Judge. I had to leave.
Stop.
to
That's why
come-
we have Zoom. Don't be silly.
Yeah.
Do you
And,
need anything or can we just?
No, I mean, not. I don't need anything, Judge. And Torres has out of county holds. I'm not on the fugitive list. I don't know if it came to me by accident, but I got 2 of his cases. I put it the newest one. I'll put the second one in there.
Okay, let me
I
see.
don't
Hold
need
on.
anything from you, Judge, on either case.
So you said you got Torres.
Yeah, I got Torres and I got Hannah.
Okay.
On
do you just
Torres,
wanna
I got
look at
both of his
them?
cases. Yeah, on Torres, I got both of his cases.
Okay, yeah, I mean, hey, so he got Torres too, back, both in the holdover.
Oh, yes, Torres.
When do you want, Martin? You want a week?
Yeah, sure, that'd be great, Judge.
His felony 5-5. Did he want 5-6?
Do you want the day after the felony or do you want it sooner? What do you want on
Oh,
Torres?
for Torres, we could do
Yeah.
after the felony on Torres.
5-6.
Okay, 5-6.
Okay.
And then
And
on Hannah,
Hannah, we could do like 2 weeks on Hannah, Judge.
yeah, whatever you want. It
Let's
doesn't
do
matter.
2 weeks on Hannah, Judge.
April 21st through the 23rd.
The 21st is fine.
Okay.
Thank you, Judge. May I
Have
be
fun,
excused?
man.
Thank you.
Got it.
Bye.
Okay, counsel, ready?
Yes, sir.
Hey, just the last name of your client.
Brown.
Brown. Okay.
Then I wanted to see if you would, remove the no contact from the gun condition.
Why?
So you see, comparing witness is his mother and she's in the courtroom.
I haven't had a chance to talk to her yet.
Where is she? That's mom?
Yes.
You want to go? Okay, we're gonna have the state talk to her to make sure that she's okay with it and we'll go from there. Okay, so give them 5 minutes and,
Okay.
yes, okay.
I have another one.
Who's your other one?
White person.
Okay,
For that one, there is urine test requirement, random urine test station.
no. I didn't, well, I put a monitor on his ankle so we know he's not using.
Oh,
That's what we did. No, my concern is alcohol. I don't want him to drink. So we'll put, that way we know what's going on. Yeah, oh yeah, absolutely, of course. Yeah.
thank you.
Okay, for sure. Ruben,
Hey, Judge.
hey,
Okay, so sign the documents for Varela.
Yes.
So he's
What do you
in
want to do?
jail, bail review.
do you want to reset for a couple days to check it out?
What do you mean?
Would you like to do with Varela? Varela. We got to do something with it. Either he pleads, you get more time, you tell me. What would you like to do?
Judge, can I get a regular recess so that? we
Yes,
can
of
download
course.
everything?
Yes, of course. Yeah, whatever you want.
And then we'll see if we just need.
He'll need bond conditions, so we need to bring him out to sign bond conditions. Does he have a license to drive?
No,
Okay, so I'm also going to put a GPS monitor if he does get out of jail.
okay.
Okay,
All
and
right.
then no drugs, no alcohol. Hey, Edge, you didn't send Varela down, did you?
It's bad.
Page 56.
Okay, I need him to sign conditions. Hey, on page 56, do you have Varela? No drugs, no alcohol, no driving, and a GPS prior to release if he does bond out. Please,
Yes.
random testing.
What's good? Did you see the motion, sir? Oh.
Yeah, I signed it already. Lonnie,
Yes, Sean.
So you're gonna take a look at it.
got it.
How much time on Varela?
Whatever he wants. I know, but I need to give him at least one setting so he can take a look. At least 30 days. And at that point, you know,
All right.
yeah, but hey, Ruben,
Yeah.
be ready, man. You know, it's old.
I expected the case. She was already done.
Okay, Mr. Knowles, you ready?
As ready as I guess I can be. I mean, if the government's ready, I'm ready. I don't know if they're ready or not.
Laura handling it, so let me go back there.
Okay,
Look at the witnesses or not, so we can see.
we do. We have a witness for the probation officers here.
Can we go over a few?
Yes,
Bottom of 19. Except for Raymond, I've reached out to council or emailed council several times, no response.
okay, 10,002.
No, defendant.
Oh, defendant's here.
Yes.
I guess roll it till tomorrow or roll it till Wednesday.
All right, guys, 19 is-
Must appear.
Yes, sir. Bottom of 31, Samuel. Come on up.
Did Mr. Samuels just get here?
You checked.
No.
Twice and got that. Maybe.
So it's now 12:15. Let's send him home with an application. Mr. Samuels, you're charged with theft. Crap, I don't have a. Just, Mr. Samuels, take a seat for me in the jury box. I don't want to lose you. In the jury box, take a seat. Yeah, his name. I don't have a DA. Okay.
Bottom of 32.
Okay.
Beta. Data.
Just do another THA.
Bottom of 34, mid, first initial J.
Okay, I guess same thing, another THA.
Yeah. All right, go ahead and sign, please. All right, we'll just do it one time.
Find anything?
I did. So, while this gentleman may be eligible, his brother is not the actual person who has the firearm. He's not eligible to possess a firearm. So obviously I'd be opposed, to say nothing of the fact that this was a file and a hearing set required by the code. So in both aspects, it's not even a denial at this point. It's not even set properly.
So it's not his gun, though, it's someone else's gun.
Well, no, that was the information relayed to me. I don't know what the original charges are.
Sir, come up.
Mr. Hernandez.
Whose gun is this?
Oh, that I don't know, but it is from the originating out of county charge. It came out of Dallas, and so it was a different adjudication, obviously prohibited. I would need to get a copy of the offense report to see.
So are you saying he's currently on probation?
No, he's concluded, he is eligible right now. But the other individual from whatever stop that was that originated out of county extradition, that individual, for whatever relationship it is to him, he is not eligible. And that deferred is still pending. So even if that wasn't the fact, is that I'll still be opposed in the event that the deferred is revoked, and then they would want to put it for an MPG hearing. So I would be opposed. This is still pending litigation. It's obviously not with an MHA. Not pending litigation over case.
So you. 2610. The cause numbers that you put on this motion are for a Reynaldo Hernandez.
He's the one that they put the charges with him, but they were inside the house, but like they got him inside the house, so they took and put it with him, but they were mine. One of them is mine. I don't know why they took them, they were inside the house.
But the problem is that what happens if I give this gun back to you and then he comes back and says, well, the gun is mine?
No, it's, I mean.
Well, I know that you're saying no, but the possibility exists. I have given a gun back before to the wrong person. And I now want to make 100% sure that.
I'm 100% that he won't reclaim it or.
I understand, but the possibility always still exists, number one. Number two, that person is not even allowed to have a gun. You know what I mean? I can't at this point. I'm sorry.
So what can I do? Well, I gotta wait.
What I would do is just talk to a lawyer. I cannot give you legal advice. I mean, I can get in trouble for trying to give you any kind of legal advice. I'm just not allowed
I
to.
did pay a lot, sir. That's for the receipt for that, the reason I'm coming now.
But the offensive report connects the gun to him. That's the problem.
Yeah. Well, it wasn't, I guess because it was inside the house. And
But how do I know all these things? I don't know any of this.
And Your Honor, before we start to know facts, again, I remind the court that he's still under deferred adjudication. So in the event that they revoke, they want to put the underlying charges. He's talking about the facts of the case. He should get a lawyer because if he was.
Best just not to say anything at this point.
Just give it away.
Yeah. Okay. Yeah, for sure.
Okay. Thank you.
That's it. No, well, I don't know.
I mean, at the end of the day, it may be just cheaper, guns are cheap anyways, you know what I
Like,
mean?
it was registered to me, so I just figured it was easier if I just show my face. Thank you, sir.
Sorry.
Just on, Flores, Dennis. And, the magistrate put the conditions only in Spanish and pre-trial needed them in English and in Spanish. I just want to know how we proceed with the conditions.
However you want. No matter. You can do both.
Okay.
Do you want to do both?
It's just so we can't enter it into our system if it's only in Spanish.
Okay, then do it in English. Yeah. All right.
Oh, yeah, come on up.
Ramona, you ready? Or no, we're still waiting on, oh, can I borrow you for a second?
So, Barbara can be handling.
I know, but I have PC on someone else.
Oh, sure.
Yeah.
Absolutely.
Oh, yeah, right this way.
Sorry, look.
That's okay.
She wanted to argue this, so, and then she's going to recall.
Right. I think we're doing. Samuels, come up. This is Samuel.
She's in the witness room.
Mr. Samuels, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We called you a lot earlier. Court starts at 8:30 in the morning, not at 10:01, not at 11:35. It's now 12:35. So the next time, please be here on time. Okay? I called you multiple times myself and you never answered. Okay? So next time, try to stay here. You're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. Where's this theft from? Okay. As a condition of your bond, you are ordered not to go back to any target whatsoever. You understand? If you violate this condition, if you pick up a new case, I will revoke your bond. There are no more PR bonds for you. This is not a revolving door. You understand? Okay, we are going to reset your case, give you time. Would you like the court-appointed lawyer or would you like to hire a lawyer? Okay, we will send you home with a financial affidavit. I need you to fill it out. And when you come back, be here on time at 8:30, not at 10:01, not at 12:01. Do you understand? That's when, it doesn't matter, but that's when we give out lawyers. We do it earlier. By this time, everybody has already left. Okay? All right, please. Can you file this conditions part of your text?
So, but I can put that.
Ready to go over with you?
Yeah.
Hey, Suja and Rach Alexander.
15,001.
15,000.
Bottom of six, Judge, top of seven, drop. Settings, having part trouble.
2501 on both. Hey, Adam, come on up.
I have a future case reference,
Okay,
and I'd like to request on.
okay. What's the last name?
It is.
Masato, Judge.
Masato.
With an M?
Yes, Judge.
State?
I'm going to be opposed. He's one for grand theft and Florida Communication Fraud Act scheme to defraud.
Wait. Okay, there's a fugitive. Yes, got it. Okay, I'm sorry, I didn't see it.
I'd be opposed to the bond judge. He's wanted for those two charges. But he also has an outstanding bond of unlawful carrying a weapon here in Harris County, along with falsifying a drug test. Obviously, you can see his lengthy criminal history in our jurisdiction, even within the past 5 years. Along with that, he has, I believe, one charge out of county. But the demanding jurisdiction is opposed to a bond. They have a bond set there, but obviously you can't make it into self-surrender. It's $100,000.
100,000.
In that jurisdiction once he goes in. But they are emphasizing that they do not want.
Do you mind bringing out Mr. Masato when you're done?
It's weird. It's not even two. Oh, basically. Like everybody I talk to, I don't understand. I've had to argue with multiple people today. It's like, you can't get a bond out of state. I'm pretty sure I know my job. It's like, I don't want to go around with you. Like, okay, I don't know what to tell you. So,
Is that regarding this case?
yeah.
Okay.
So
I'll give you a chance as soon as we get out.
So, obviously, a couple times in life. I have to point out the equivalent of their code of procedure, penal code, or whatever it is.
Hey, Farwa, are you ready on yours?
Yes, sir.
We'll do it next. No, on the probation.
Yes, sir.
Okay.
Really long ago.
Did you need them? Are we starting?
In about 2 minutes.
Oh, this probably happened. What's going on? This one. Oh, it's happened to the state of the home.
No, he's not. They're both in here. Good morning, Mr. Masato. Your lawyer is asking for me to set you a bond. I don't know. I've never met you before. I have about 2 minutes to get to know you. I know that you're going to tell me everything is little bunnies jumping in the woods and gumdrops and rainbows, but paper really tells me who you are, because people will tell me everything I want to hear. You've great jacket, great hair, everything, right? But paper really tells me who you are. State.
Your Honor, he's one out of Borough of Florida for 2 charges, grand theft and the Florida Communication Fraud Act scheme to defraud. State would be opposed to a bond. He is also out on bond for unlawful carrying of a weapon and falsifying a test. As you see in the local criminal history, he's had multiple charges of DWIs resulting in convictions, multiple charges of assault family member resulting in convictions, 2 charges of marijuana, 1 that was pled down from a felony amount, and in possession of controlled substance that was dismissed in 2009. He's had this larceny warrant out for 3 months, Judge. But due to those reasons, state would be opposed to a bond.
Yes, Your Honor, and I note that Mr. Masato does have a full-time employment as an electrician, so he does have the resources necessary to travel back to Florida. He does understand that if he does get out, it's absolutely not optional that he does have to go to Florida within those 14 days. He is also a father. I'd also note that I understand that we can't certainly can't litigate the Florida cases here, but he does strongly contest the allegations in Florida, and he doesn't look forward to contesting those in Florida once he gets a chance. So Judge, I would ask your honor to give Mr. Masato the chance to throw himself into Florida and not just have to wait here for Florida to come get.
I got to be honest, Mr. Masato, you scare me. You know, you, within the last couple years, you've continued to pick up case after case after case. And not only in Harris County, but you're hitting other counties. You're hopscotching with jurisdictions. You said you got something in Montgomery County as well?
So it was Galveston, but it was the dismissal of unlawful carrying of a weapon in 2023. So obviously during the pendency between the other cases. But I just noticed here is that he recently had 4 Class C dispositions. Normally I wouldn't bring it up, but in terms of transportation for him self-surrendering, he didn't have current registration. He didn't have current insurance ×2. Well, the headlights don't matter. So I don't even know if he has the feasibility. He can't fly because DSA will arrest him. So I don't even know if he has a valid way of getting back. So.
I would just note that he doesn't plan to get to Florida by taking a plane there. So
You can't take a plane. You've got a warrant. If you try to get on a plane, they're going to arrest you. You can't get on a plane.
You can take a bus here on.
My concern more so, Mr. Masato, is that you leave a wake of destruction. We have, I know you say no, but you're on bond for 2 cases. You picked up a larceny and is it 2 cases or one out of it?
Grand theft and then the sneak
It's just too much drama, man. Too much. At some point, you have to understand that we are concerned about public safety. And you are now, just in Harris County, 1, 2, or let's go through it. Possession of controlled substance, theft, weed, DWI, assault, DWI, weed. You've picked up 2 felonies in Florida. You pick up 2 more cases here. You got something in Galveston. When do we say when? When is enough enough? Because if I give you a bond now, I'm telling you that this behavior is acceptable when it most certainly is not. The good news is that you've made bond on these 2 cases. So Florida has 14 days to come get you. If they don't come get you, at that point, the Harris County will release you. Do we know whether they are going to come get him?
They do want to get him. They haven't given me a pickup date yet because the waiver.
I'm not going to wait. So they've got 2 weeks to come get him. If they don't come get him in the 2 weeks, then I'm releasing him.
Yes, sir.
Understand, if Harris County, if we do release you because they don't come pick you up, that Florida warrant will always remain open until you go back to Florida and take care of it. Do you understand? I cannot keep perpetuating the same thing over and over. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. You're on number 14, Mr. Masato. Enough is enough. Do you understand? Good luck.
So if you reset the 4th one,
He's waived already, right?
He's already
You said?
waived it,
Okay,
so.
yeah.
So, thank you.
Thank you.
Thanks, Adam. Matt,
Yes, Your Honor. May I?
can I show you something real quick?
Yeah, please.
But I'm live streaming, so don't say anything, but I want to show you something. What is the cause name? Okay, hold on, let me see. I got it. It now seems to.
Oh, I know exactly what this is all about.
But do you know what happened upstairs?
So, I don't know.
He's in compliance now.
I know.
These
So-
happened before the fact.
Correct. And so he's got a bond, his family wants me and he wants me to go talk to him about the new situations and so forth. So I know what that is. And I need to go.
I don't know what we should do on ours, whether we should, because I can't just I'm looking for me. I don't want to revoke him because he's not really, other than these, they're not new, so.
Is he on PTI or is he on?
No, he's on regular. And he's nearly done too. All he has left is one VIP.
Okay, all right. Give me a few days, I'm gonna do
Yeah, take your time. I mean, we'll hold for some time, I guess, but we can't do it indefinitely. Those things can play for 2+.
I know.
So.
Apparently, I mean, this just recently, and I people talk about it right before the holidays and stuff.
Just keep us in the loop if you don't mind. If you're going to, if not, then obviously some, right, but, I guess let's give it like a week. If we don't hear from you, I guess I'll bring it back in all points, you know?
I'll
So,
figure it out.
yeah, just let me know. I just want to keep you so we don't,
I got it.
yeah.
We're good.
All right.
Thank you, Judge.
Fran.
Appreciate it. Thank you for the heads up.
This is given to the property.
That, you made it. Hi, nice to meet you. Yes, yes. Tell me.
Brown.
Yes,
I think this gave your to Bob.
okay.
And she said it's okay.
Can you just give me a brief rendition? How bad are we
Yes,
talking?
so. Push her in front of the thicker phone, slap her away.
Okay.
And then lock the door. Not opposed to playing and harassing.
Mr. Brown, come up. And there is a protective order that has been issued, right?
There's more up here.
And she's okay with contact, you say?
Yes, sir.
Okay. Mr. Brown, there is a protective order that has been issued and you need to get to know it. I don't care that it's your mom. I don't care that it's your grandma. You put hands on anyone, I'm going to put my hands all over your bond. I'm going to put you in jail and I'm going to make your bond high. I will protect my community at all costs. Do you understand? I don't care that it's your mom. I don't care anyone. Any circumstance you violate these conditions, it's just not going to go well for you. I am now order you not to have any threatening or harassing contact. What is threatening or harassing is, doesn't matter what you think it is, it's what she perceives. Do you understand?
Yes, sir.
So if you raise your voice at her because she tells you to clean the kitchen sink, that may very, very well be threatening and it could land you in jail. You understand? Madam, any issues whatsoever, just let them know and we'll take care of it for you. Okay? Okay. All right. Good luck.
Thank you.
Do you mind filing those? Or I don't know. Did we hear?
We do have the other
So-
ones, but they will have.
But I'll modify it.
Okay.
Let me see.
Yeah, so they're in your
Because I can
file.
just, let me see where.
Yeah, they're in there.
Okay. I will take out and then I'll just put down here, no threatening or harassing contact with the complainant. Thank you. Are you ready? Guys, we're about to go on the record. If you want to talk, please go outside. Jennifer Gonzalez, come up. Lonnie's right here. He's right there.
Hey, Judge, can I start right here? Yeah. Thanks.
So you can come up. We don't have to be so formal that you're out all the way over there. Would you like to come up? Yes, ma'am.
Sure. Thanks.
Are you ready, Ramona?
Yes, Judge.
Okay. Oh,
Yes, Judge.
do you mind giving me the cause number real quick? Or maybe I got it right here. I got it. All right, we are on the record. Cause number 2519399. This is the state of Texas versus Jennifer Gonzalez. Today's date is April 6, 2026. It's approximately 12:40 p.m. Guys, I want to, if you don't mind, please, with the state going first, announce yourselves for purposes of the record.
419 for the state of Texas.
Lonnie Knowles, Knowles for the accused, Ms. Jennifer Gonzalez, Gonzalez.
Okay, and if you don't mind also, ma'am,
Lanicia Harris County Community Supervision and Corrections Department, LAK, NESYA, last name LUK.
do you mind raising your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, ma'am. Thank you so much. So for purposes of the record, we are here because we are having a hearing on a motion to revoke probation. Ms. Gonzalez was arrested for driving while intoxicated. It is a second offense. And she was arrested on July 12th of 2024. Mr. Knowles has represented her throughout the entire proceedings, and she was placed on probation in November of that same year. Actually, she was placed on probation November 27th of 2024. Let me make sure that you did put her on probation because I'm not sure. Yes, Mr. Knowles files a designation of attorney in charge, and a motion to sub was also filed on August 6th of 2024. Initially, she must have had other counsel. Yes, we appointed her a lawyer, and he was subbed out on that day. She was placed on probation. It's come to my attention that there have been multiple motions to revoke probations since that time. Do you want to take over?
Yes, Your Honor.
Judge, before we proceed,
Okay.
just for procedural purposes, I want to make sure that the motion to revoke community supervision, that is the active pleading before the court to which we are here to respond, is the one that was filed on October 24th of 2025 at about 2:10 p.m. And if there's another one that I'm here to try to defend against him, I'll need to know, because that's the one that I've got to know, so.
Yes, Your Honor, it's the one filed October 25th at 2:10 p.m.
Is that the right one?
Yes, Judge.
Are you sure?
I believe so.
Take your time to look. It's not a big deal.
There was a prior one from April 10th, but we addressed that one, so I guess hold on.
So there was a subsequent motion filed for another violation that Ms. Gonzalez had.
Yes, sir.
But we're going on the one before that.
I think they're going on the one after that.
Is that okay with you, Lonnie?
Yes,
Is that the motion that you're?
Prepared for. Is
Okay.
the one that I just stated, the one dated October 24th of 2025, that was filed at 2:10.
Okay.
Judge, I'd like to introduce a certified copy of the judgment for cause number 251-979-399-01010, and its accompanying conditions for probation. Pre-market state exhibit 1 tendering to defense.
Judge, I'm not going to have an objection to the government's exhibit number 1, but so that the record is clear, the exhibit itself contains several different documents. The first one is going to be the actual judgment. There's also conditions of community supervision. That is 3 pages, 4 pages long. And then there's also what has been designated as a first amended conditions of community supervision, that is 2 pages long. And then there's also a second amendment conditions of community supervision that is 3 pages in there. So with that, I have no objection to those documents.
Okay, they'll be admitted. So they have how many motions have been filed? And how many are you aware of? State?
Yes, Your Honor. There have been 3 motions to revoke filed. We are going on the one that was filed on October 25th and addressing those violations.
Okay,
It's actually the 24th
Oh, yes, I'm sorry, 24th.
okay.
of 2025.
At this time, Your Honor, I'd like the court to take judicial notice of, or, I'm sorry, Your Honor. State would like to introduce State's Exhibit 2, the motion to revoke community supervision, tendering to defense for inspection.
Judge, I have no objection to what's marked as State's Exhibit number 2, that being the motion to revoke community supervision.
Okay,
It's a
it'll be admitted as states 2.
4 page document.
Do you have any further exhibits? Or is that it?
There's one. No exhibits at this time, Your Honor. State, Your Honor, State is ready to call its first witness.
Okay,
State calls Ms. Lucia Lucian.
okay. This witness has been sworn, so you may.
Ms. Luke, may you please state your name for the record?
Lenicia Lou,
And what is your occupation?
a community supervision officer.
In your capacity as a community supervision officer, do you have care of custody control of the probation file or the Harris County Community Supervision and Corrections Department?
Yes,
And are these records kept in the regular course of business for the Harris County Community Supervision and Corrections Department? And is it the regular practice of the department to keep such records?
yes,
And are the records made at or near the time of events that they represent?
yes,
And are the records made by a person with personal knowledge of the events?
yes,
Do you have a file compiled for a person named Jennifer Gonzalez?
yes,
That's maintained by the Harris County Community Supervision and Corrections Department?
yes,
And you see Jennifer Gonzalez in the property today?
yes.
And can you describe her by a piece of clothing?
A tan sweatshirt and camouflage pants.
Your Honor, may the record reflect that the witness has identified the defendant.
Okay, they will.
And has the file for Jennifer Gonzalez been maintained under the conditions you previously described?
Yes.
Judge, at this time, I'd like the court to take judicial notice of the court's file that's been kept in the regular course of business and maintained under the previously specified conditions pre-marked as State's Exhibit 3.
Okay, Mr. Knowles, we take a look.
Ideally, I want to have some time to kind of take a look at it.
And your the file was emailed to him, so he did have possession of the probation file. I believe your email was sent on March 19th.
I'll have no objections to it. If it is in fact the file from the probation department, and that's what this is supposed to be?
Yes, it's a probation file.
Okay, and this is the one that Ms. Luke will have?
Yes, it's the one that that's testified to.
Okay, I'll have no
It'll be admitted.
objections to being admitted at this time. I'm
Got
not
it.
have questions about it.
States 3.
Ms. Luke, please tell the court when the defendant was placed on probation.
November 27th of 2024.
And for what offense was the defendant placed on probation for?
Driving while intoxicated.
And what charge number was that?
That's 2519399.
And what court and county was that?
Harris County Court Number 5.
And according to your records, what is the duration of the defendant's period of supervision?
16 months.
And has the defendant's probation been terminated?
Technically, yes. The full term date is passed.
Is there a form in the file explaining the terms and conditions of the defendant's probation?
Yes.
And is it the regular practice of the Harris County Community Corrections Department to review the terms and conditions of probation with the defendant?
Yes.
And is there documentation in this defendant's case where the terms and conditions of her probation were explained to her?
Yes.
And was she given an opportunity to ask questions or clarify what was expected of her on the
Yes.
state? And is there a place for the defendant to sign indicating that she has read and understood the conditions of the probation on the state?
Yes.
And did the defendant in fact sign the forms indicating that she understood the terms and conditions of probation on the
Yes.
state? So after the defendant signified that she complied with the terms of her probation, did she actually comply with the terms of her probation?
No.
And was her failure to comply documented?
Yes.
And do you have a copy of the documentation and motion in the court's file?
Yes.
So. And. So was the defendant given a condition? Sorry. So was the defendant given the condition to report to community supervision officer as directed for the remainder of her supervision term unless so directed differently by the court?
Yes.
And what paragraph was that in this community supervision?
Condition number 2.
And did she comply with that condition?
No.
And can you tell the court how she failed to comply with that condition and how it violated her probation?
She failed to report on October 1st of 2025. And did not report after that.
She did not report anytime after that. Was the defendant given the condition to not use, possess, or consume any illegal drug or prescription drug not currently prescribed to her by a medical professional?
Yes.
was part of the condition that she should bring all prescription containers to the community supervision officer. And if new medication is prescribed, she must bring a new prescription container by the next scheduled report date.
Yes.
And what paragraph is that in the community supervision?
Number 17.
And did she comply with that condition?
No.
Please tell the court how she failed to comply with that condition and violated her probation.
I submitted a positive UA for THC on March the 5th of 2025. And subsequently, a positive UA on April the 9th of 2025 for amphetamines, methamphetamines, and opiates. I'm waiting on this. Yes.
Was the defendant given the condition to attend the education program thinking for a change until completed or designated, or as designated by the court?
Yes.
And did she comply with that condition?
No.
Can you please tell the court how she failed to comply with the condition and violated her probation?
This, I'm not able to attest to.
You're not able to attest to this. And what paragraph?
But it is in her conditions of probation.
Yes, and what paragraph in her conditions? of
Number
probation?
20.
Was the defendant given the condition to participate and complete two DWI victim impact panels by March 27th, 2024?
Yes.
And did she comply with that condition?
No.
Can you please tell the court, or what paragraph is that in the
Number
condition?
21.
Paragraph number 21? Did she comply with that condition?
No.
And can you please tell the court how she failed to comply with that condition and violated her probation?
By felonies completed by the court order completion date of March 27th of 2024.
Was the defendant given the condition to participate in and complete within 180 days from the date community supervision is granted an approved alcohol or drug education program?
Yes.
Texas DWI intervention program for repeat offenders?
Yes.
Was part of the condition to comply with all program rules, regulations, and guidelines until successfully discharged or released for the order of the court?
Yes.
And what paragraph is that in the conditions of supervision?
Number 22.
And did she comply with those conditions?
No.
Can you please tell the court how she failed to comply with those conditions and violated her probation?
By failing to complete the program within 180 days from the date that community supervision was granted.
Did she even attend the class?
Not to my knowledge.
Not to your knowledge? Was the defendant given the condition to have a court-approved portable alcohol monitoring device by December 4th, 2024, and to comply with all vendor rules, regulations, maintenance, and costs pertaining to the use of the device until successfully discharged or released by further order of the court?
Yes.
And what paragraph is that in the conditions of community supervision?
Number 24.
And did she comply with that condition?
No.
And can you please tell the court how she failed to comply with that condition and violated her probation?
By failing to maintain the device.
Did she make any attempts to obtain the device?
Yes.
She made an attempt to get the device?
Yes.
And why did she not get the device?
No, she did get it. She
Oh,
didn't maintain.
Oh, she didn't maintain it?
Yes.
Was the defendant given the condition to attend an inpatient treatment program as directed and remain in the facility and comply with all program rules, regulations, contracts, and guidelines of the program until successfully discharged by further order of the court?
Yes.
And what paragraph in the conditions of community supervision is that?
What's on that in there? The second amended condition number 29.
And what paragraph is that?
29.
And did she comply with that condition?
No.
Did she make any attempts to enter the program? Or
Yes.
enter into the program?
Mm-hmm.
She did not remain in the facility?
No.
Can you tell the court exactly how she failed to comply with that condition?
We were unable to maintain or obtain verification that she successfully completed the program.
This is the one where she chose to go to
Yes.
that outside facility and it
Yes.
was an inpatient.
Yes.
Right, okay.
And as a result of the aforementioned violations of the terms and conditions of her community supervision, did the defendant's community supervision officer file a motion to revoke probation?
Yes.
And on what date was that filed?
October 24th of 2025.
And was the motion to revoke successfully signed by, or subsequently signed by a judge of the 5th Criminal District County Court at Law?
Yes.
And on what day was that motion signed?
By October 23rd of 2025.
Pass the witness.
Commissioner Knowles,
Steve John.
please.
Ms. Lou, my name is Lonnie Knowles. I'm having a few questions for you if that's agreeable with you.
Yes, sir.
Okay. Let's get one thing established, I guess, right off. We rip, as the kids would say. You, before today, had only seen Jennifer Gonzalez one time, isn't that correct?
I can't say how many times I've actually seen her.
And why is it that you cannot say how many times you actually saw her as a probation or as your capacity as a probation officer?
I keep count specifically.
Is that not something that is maintained as a part of y'all's?
Yes, if you like me to count, we count.
No, I like for you to count, please, because I'm thinking you've seen it but one time.
It appears to be twice.
Could you share with me those dates in which you actually saw Ms. Gonzalez?
March the 3rd of 2025. And January the 13th of 2025.
No, March, you said March the 3rd of 2025, and what was the purpose of that visit? For you seeing Ms. Gonzalez?
Regular monthly probation visit.
Did she visit you at the office there?
Yes, sir.
And where was that?
Where's my office located?
Yeah, but.
3330 Coles Bench for.
Okay. And on January 13th of 2025.
Okay.
Was that another regular office visit?
Yes, sir.
Okay. Did you have her test or anything for drugs or alcohol on March the 3rd of 2025?
No.
Do you have a test for drugs, alcohol, and other controlled substances on January 13th of 2025?
No, sir.
With respect to, I'm gonna call it violation allegation number 2. Okay, do you have that pulled up?
Yes.
Okay. So the allegation is that she failed to report to the community supervision officer that she failed to report as directed on October 1st of 2025 and has not reported to this community supervision officer since October 1st of 2025. You understand that to be the allegation, right?
Yes.
Now, what actually happened is Miss Gonzalez contacted you as she was directed by telephone, didn't she? And at that time, you requested of her that she either give you information or alternatively have someone from the facility that she was in to contact you, right?
Yes.
Okay. As far as you know, Ms. Gonzalez did in fact contact the therapist and the people at the facility she was at to get in contact with you, right?
I'm not certain. I never received any documentation.
Okay. And what efforts did you take to try to contact me?
I made several phone calls and sent emails.
Okay.
And
then
the court probation officer also reached out to the agent.
let's talk about what you did first, okay? We'll get into that.
Okay.
You made some phone calls. What else? And you sent some emails. And what else did you do?
That's it.
The phone calls went unanswered, but it wasn't like the phone was dead and happy, right?
Correct.
The emails went to people designated that were at the facility there at Greenhouse, is that correct? And as far as you know, none of those emails bounced back as being undeliverable or otherwise not being received.
Correct.
You would agree with me that Ms. Gonzalez has no control over whether or not the people at the facility either respond to you by email, right? Or return your phone call.
Correct.
You also understand that there's certain obligations that those types of facilities have with respect to the divulging, is that a word, divulging information about patients. You understand what's called HIPAA concerns, right? Did you ever address the Greenhouse facility with, listen, if you need a HIPAA release in order to contact me, let me know. You never did that, did you? And as far as you know, nobody, either from you said the probation officer or the CLO, you know, she did that either, do you?
No, I'm not.
Okay. But you do understand how that would have maybe gotten you a response that would have cleared the liability that either probation would have had or the Greenhouse would have had for releasing information regarding the patient.
Correct.
But you didn't do it. So would you agree with me that Ms. Gonzalez did all that she could do to try to have you be able to enable you to contact the facility where she was, right? She told you that she was going to go in and directly contact the therapist, Ms. V of Veronica, to get in contact with you, right?
Your Honor, speculation.
No, she told her. Ms. Gonzalez, I'll rephrase the question. Ms. Gonzalez told you, Ms. Luke, that she was going to contact a therapist there to be in contact with you.
Yes.
Do you have any missed calls from that facility that you are aware of?
No.
Would you have expected Ms. Gonzalez to do more than give you the name and the contact people at the facility and or tell you she's contacted them directly herself so they can be in contact with you? What more would you have to do?
Still provided a completion certificate.
I understand that. We're gonna get that in a minute, but I'm saying what more with respect to this number 20?
That's what I would expect.
That's the more you would expect is to have been provided with a completion certificate. Okay? Have you seen that before?
Yeah.
Let me show you what I'm going to mark as defense exhibit number 1. Now, post-exam. I'm going to ask you if you have ever seen what I've marked as defense exhibit number 1.
No.
Okay. In fact, wasn't this took the document shared with you by the CLO who's sitting over here to our left after I had given it to her and it became a part of your file.
I'm sorry?
If this certificate would have been shared with the CLO, the court liaison officer, and asked to be made a part of the file, then we would have expected for this certificate of completion to be a part of the file, wouldn't it?
Yes.
Did you see that there was or was not a certificate of completion, the one I'm holding in my hand, made a part of your file?
No, that was dated after this motion was filed.
And I understand that. My question was a little bit different though. Did you see within the documents?
No.
The certificate of completion that I now marked as defendant's exhibit number 1?
No.
Do you quarrel with me at all as to whether or not this certificate is certifying that Jennifer Gonzalez has successfully completed treatment at the Greenhouse Outpatient Facility on the 23rd day of January 2026?
No.
Let's go to number 17,
Okay.
which 17 being the paragraph that is alleged to have been violated and the motion to revoke. You said something about an allegation of there being a violation occurring on March the 5th.
Mm-hmm.
Okay. But that's not alleged in paragraph 17, is it? A violation of March the 5th?
No, it's not.
So we don't have any notice about that alleged violation. That's going to be part of this hearing, then, isn't it? Okay, so let's talk about April the 9th. Okay, and on April 9th, you said that there was a positive confirmed on the following dates, and that date is April 9th, right? Correct. Okay. You also stated that you have within your records a list of medications that were legally prescribed to Ms. Gonzalez, and for which she gave you a list of those medications, right?
I don't have any medication in here.
Sure. Take your time. Look. So you telling this court that you have within your file no list of medication or prescription medications that Ms. Gonzalez has provided to you or to the probation department that are made a part of her file? Is that what you're saying?
Yes.
And the reason I say that, and that's that way, is because when
I see something here from December of 2024.
okay, well, hold on, what do you see there?
I'll clean it up.
Okay.
There was something provided to the previous officer here.
There was something provided. What was provided?
That is for medications.
Oh, if you go. Well, you said earlier that, yeah, there was a list of medications. And among that list of medications are medications, do they have named those medications?
Gabapentin, hydrocodone, acetaminophen, methocarbamol, another one for the hydrocodone, acetaminophen.
I know you're not a pharmacist, so I'm assuming you're not a pharmacist, right?
No.
But you would agree with me, that it's those medications from which you would conceivably be able to get a positive reading of what is found as the drug specified in the April 9, 2025 testing. Is that correct?
For one of the substances.
Your Honor, speculation.
Sustained.
But you don't know, do you?
You don't have to answer the question. Don't answer.
So So there's nothing on March fifth that is before the court today. The April 9th is explained by virtue of the prescribed medication. Would you agree with me? Matt? We'll come back. The next paragraph, number 20. You quite candidly shared with us that you can't even testify to that, can you? You have no knowledge of that, do you?
Yes.
That's fine. The 21st, you said that there was a failure to participate and complete a DWI victim impact panel by March 27th of 2025. Remember that?
Mm-hmm.
Do you have any records where Ms. Gonzalez was attending classes, I think in Baytown? You have that information?
Yes.
And she was in Baytown from November to March. Is that correct?
Yeah. Okay, possibly.
Do you know whether or not the DWI victim impact panel was a part of what was being done at the Baytown facility between November and March when she was in attendance for?
Yes.
That's a wholly separate program that she had to go through. That's not offered like, or would not be offered at Baytown, right?
Correct.
And when was it that you told her, if you did, that DWI impact panel that she had to complete had not yet been completed?
This was explained to her on December the 4th of 2024 by another officer.
Now, but him on, we'll come back to that, but I want to go down to 22. Paragraph 22 alleges that she failed to participate in complete within 180 days on November 27, 2024. Community supervision is granted an approved alcohol drug education program, testing divide intervention program for repeat offenders required by Article 42 and Section 13. Now, are you aware that these were part of the program that she was not only participating in when she was in Baytown, but also once she got transferred into the inpatient facility and rehab in Dallas?
To my understanding, is not provided. It's not part of the curriculum with the program she was doing in Baytown.
Okay.
I'm not familiar if it's part of the curriculum. Yes.
So you don't know if she did that in Dallas or not? You haven't confirmed that it was or was not done, have you?
Okay.
Is anybody up there, y'all drive to Dallas?
Yeah.
Then well, I'm on 24.
Mhm.
And it talks about a failure to comply with one vendor's rules pertaining to use and then the maintenance of the device. Okay. Let's first talk about what constitutes maintenance. What type of device is it, first of all?
It's like
Then, what does it take to maintain an alcohol monitoring device?
painful. It's part of the manufacturing.
Oh. So that is what you're saying in this allegation 24 is that she didn't pay for the device.
She didn't keep the device active.
I'm sorry.
She didn't keep the device active.
And I'm not trying to game with you, but she didn't keep the device active because she had to actually pay for the device, right?
Correct.
Is that what the deficiency is, the failure to pay, not anything else, right? Correct. Okay.
Well, I mean, also showing up and having it calibrated and, I mean, I think paying is,
I'm not, I'm gonna rely on her testimony, Judge. I'm not that familiar with her. I'm not
I
sure how
don't-
much you are, but I'm gonna take some type of a sua sponte type of judicial acknowledgement of how those things work, and that's different. But then that makes you a witness and not a referee.
Mhm. Go ahead.
So the maintenance is not paying. The failure to maintain means she didn't pay.
The failure to maintain is the failure to maintain.
What constitutes failure to maintain? What are the things that constitute failure to maintain?
There's a host of things, but specifically, she didn't keep hers on, she didn't pay.
You're not paying. That's specifically what we're talking about. Right? You don't know if she had the ability to pay for it or not, do you?
No.
Okay. Are you aware? When did she go to the rehab in Dallas?
You need a specific date?
That would help. Let me see if I can help. May I approach this room, Mr. Judge?
Sure, of course.
Okay. The second minute condition of human supervision is what ordered her to be in that facility. Okay. And so that was done, if the dates and everything are correct, was done on about May the 6th of 2025. Okay. From what point was it, Ms. Lou, that she did not maintain the device? Because it doesn't tell me in here from what period of time she didn't pay anything.
I don't have the specific date. So,
But when was her last payment that you know?
I don't know when payments are made, that's reported to the monitoring authority. But the last report was done on March the 4th of 2025.
So it would have been sometimes in March, maybe?
Your Honor, speculation.
Do you know?
No,
And that means the notes aren't kept accurately. Is that what that means? If you don't, I'm sorry.
go ahead.
If the notes aren't going to reflect when the payments started or stopped, then how do we know that she didn't pay?
Your Honor, speculation.
Overrule. I mean, if you know, not, then
You'd have the notes, Ms. Luke, I'm gonna withdraw that question. You would have notes of when the payments began, right, or supposed to begin, right?
I don't keep up with the payments, that is for the monitoring authority. I know when she began being monitored.
And when she began being monitored, that is when the payments would have likely have started. Can we just? And then if you're saying that she stopped paying at some point in time, wouldn't there be some kind of a note either from the monitoring company telling you, hey, she stopped paying? Or something that you do on your own report to find out, oh, she stopped paying. When did that happen? When did she stop paying?
I don't know.
But we do know as today is March, what you say, March 4th earlier? There was a reporting.
Yes,
And what was that reporting concerning the monitor?
yes.
And what did it say about the monitor? Was it good standing?
Yep, she still wasn't blowing like she's supposed to.
I'm talking about the blow. The monitor, the maintenance was being okay as far as any payments are concerned as late as March, right, 2025, right? Would that be a fair statement?
Okay.
You saw it?
Yes.
Okay. And so if we know that she, as March 4th, she was in compliance, and then on March the 6th, she sent to rehab in Dallas, according to the second amended conditions, would she still be responsible at that point in time for maintaining and paying for that device?
Yes.
So that's not excused on any condition, is it?
Unless it's removed by the court.
And whether she's too poor to do it or not, it doesn't matter, does it?
No.
But you wouldn't want somebody to go to jail for not being able to pay a debt, would you? You don't have to answer that. Now, do you understand that when this order was amended, when I say this order, I'm talking about the second amended order, Your Honor, is what I'm talking about for the record. When this order was amended in Ms. Gonzalez was ordered to surrender herself to that facility in Dallas. I don't remember that you were in the courtroom at the time. You weren't here at that time, were you?
No.
Is there a record in your file, the conditions upon which the judge allowed, so graciously allowed Ms. Gonzalez to go ahead and surrender herself? Are there any kind of notes in there?
What do you mean?
In your file, separate from what's in here, as to the judge says, okay, I'm gonna let you do that this time. And part of it was, I'm gonna do it because Mr. Knowles made such an eloquent argument, you got your own insurance, and I'm thinking that, you know, if this doesn't work, nothing's gonna work for you, Ms. Gonzalez, but this is what's gonna happen. You will be released directly from the jail. You'll be able to go get your transportation to the bus and get your behind straight up to a facility. You cannot pass go, you can't collect $200.
There are no specifics.
There are no specifics there. You weren't here to hear that word. But you would not dispute it if I told you as an officer of this court that the judge ordered her, you leave jail, go to the bus stop and take your behind straight up to the facility on the greenhouse. You wouldn't dispute that, right?
Your Honor, speculation.
Sustained.
Do you have anywhere in your notes that Ms. Gonzalez did anything but when she left jail, get on a bus and go and check in? Do you have any notes about that?
No, I'm not.
Speculation.
If she has a notes is the question.
Do I have notes about what now?
Do you have any notes that tell you that Ms. Gonzalez went straight from jail?
No.
To the bus station, to the facility? Where was the device at the time that she left jail, went to the bus, and went to the facility? Do you know where the device was?
No, sorry, no.
It's a portable device, isn't it? Do you know if they let you take those to jail?
I'm sure they don't.
They don't, do they? You say they do or they don't?
Don't.
So if she would have been ordered to go straight from jail to the bus stop, to the facility, and she did not have a portable device with her because she was in jail, what would you expect to happen to the portable device?
I wasn't aware of her directives from the board.
My question was a little different. What would you expected to happen with the portable device that she didn't have with her because she couldn't have it in the jail?
Your Honor, speculation.
Sustain.
How long was Ms. Gonzalez in the greenhouse facility in Dallas?
They told us.
When was she ordered to go? When was she ordered to be there?
What day was she ordered to be there?
Yes.
May 6th of 2025.
Isn't it true that someone from Greyhound called you at Ms. Gonzalez's? Not Greyhound, was it Greenhouse? Called you specifically to let you know that she had arrived, because that was also a public order. They called you and told you she arrived, right? Correct. Did you make a note in your file about receiving that phone call to confirm that she had appeared?
Made a note, yes, not on that specific date. So, I have an email for them.
You do have an email from her? Correct. What is the date confirming her arrival at the facility?
May 7th.
I'm gonna again show you what's marked with defense exhibit number 1. You agree with me that it says that she successfully completed this program on the 23rd of January of 2026. Okay. With respect to paragraph number 29, I think it is within your allegation. Yeah. What? On paragraph 29, that allegation suggests that she failed to attend the inpatient treatment program as directed, to remain in the facility and comply with our program rules, regulations, contracts, and guidelines of the program until successfully discharged by further order of the court. What information is contained in your file to show that Ms. Gonzalez failed to do this?
We never received the completion certificate.
You're saying you never received it.
I didn't receive.
It was given to someone else to be made a part of the file. You don't know about that. Okay. But now that you've seen the completion certificate, they dispute that in fact she complied with number 29?
Yes.
You do dispute it?
Do I dispute it?
Yeah. You said no, she didn't do it.
No, she did. She did it.
The DWI impact Now, going back to number 21. What does that consist of Ms. Gonzalez actually doing?
Completing the program, subject to impact down.
And how long does that take?
It varies.
What would be the shortest time period that it can be completed?
Maybe a couple hours.
And what would be the longest time period that it could be completed?
Maybe 3.
Is it a matter of having to set up an appointment to do that?
No.
And that's something that could be done relatively quickly, easily, is that?
Yes.
In fact, if the judge was to go ahead and allow her to go ahead and complete that, that could be done later today or tomorrow.
Yes.
Yeah. Ms. Luke, those are all the questions that I have for you. This 10 seconds, but Ms. Nagvi may have a few more for you.
Ms. Luke, whose responsibility is it to report to you?
Jennifer.
It's the defendant's responsibility.
Yes.
It's not somebody else's. It's not somebody at the facility she was in.
No.
In Dallas. And did her contact information ever change?
The clients,
Yes.
I think she provided me with them, just that number once before.
And did you reach out to that number?
Yes.
And you never heard back?
I spoke to her, but she never showed up.
She never showed up. But her information never changed.
No.
And it's her responsibility to report to you,
Yes.
not the facility she's in Dallas.
Correct.
In regards to community supervision paragraph number 17, I want to revisit that under the condition she's not to use, possess, or consume any illegal drug. And the defendant did use, possess, or consume an illegal drug.
Correct.
And on what day was that?
April 9th, 2020.
And what did she test positive for?
Amphetamines and methamphetamine. She has the prescription for the others.
In regards to paragraph, community supervision, paragraph number 21, the defendant failed to participate in complete a DWI victim impact panel.
Correct.
And did you say those are not too time consuming?
No.
So she could have done them in one day? Did she ever complete one?
No.
So she could have completed them in a day.
Correct.
She just never did. In regards to community supervision, paragraph number 24, defendant did not maintain and use a portable device.
Correct.
Can you explain to the court what maintaining a portable device means?
It comes with a host of things. She was required to pay for it. She has a flow schedule where she's required to belong to the device 3 times a day. She has to take the device to get it in, to get calibrated. And I always explain to them when they go and pick up the.
So she understands how to maintain the device. And did she ever communicate to you that she can't pay for the device?
No.
Did she, did she ever come in to get it calibrated?
It doesn't go to me, it goes to, she goes to the, she should have gone to the monitoring authority.
Did she ever go to the monitoring authority to get it calibrated?
She did.
And then but she
Didn't
didn't
follow up.
She didn't follow up on it. So she failed to maintain it. In regards to community supervision, paragraph number 29, defendant failing to attend the inpatient treatment program. Did you ever receive a certificate of
No.
completion?
No.
Did you ever receive a certificate of completion from the court liaison officer?
No.
Is today the first time you've ever received that
Yes.
completion certificate? And there's no completion certificate that came directly from the facility?
No.
Your Honor, counsel witness.
Just a couple of questions, Jeff, I can't follow. Did you send an email with the same place that you sent to confirm her arriving there? Did you send an email to that same email address requesting confirmation of her completion of the program? You did send one to that same address? And when did you do that?
The last email was sent on July 14th of 2025.
Did you ask in that email for a certificate of completion or some confirmation of completion of the program?
Yes.
What did you ask for?
Well, I asked them to, will they can please confirm that she was still in the facility?
No, I thought completion of the program.
No.
You never asked about that, did you?
No.
You ever sent them an email that said, can you please confirm whether or not she has or not completed the program and if so successfully or not?
Correct.
I'll pass the question.
Okay, anything further from this witness?
And nothing further from the state, Your Honor.
Okay, thank you for coming and testifying. You may be excused.
Thank you.
Okay, I think you guys want to do argument and then,
There may be another witness when you need to talk. Well,
right, well, do you rest?
State rests, Your Honor.
Okay. Mr. Knowles, do you have any witnesses?
Judge, I do. I'm gonna call the CLO.
Okay.
Listen.
Do you mind raising your right hand? And do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I swear.
Do you mind identifying yourself for purposes of the record, please?
Victoria Hoax, SHATORIA. Hoax is HOGES, and I'm the seal.
Okay,
May I
please.
proceed, John?
Yes, sir.
Ms. Hobbs, would you please describe to the record exactly what your duties are as CLO here in County Government 5?
Yes, so I just maintain all the records. I document everything that occurs in court and that's pretty much it.
I don't want to put you on the spot, but I do need to ask you, if you recall, whether or not I bought you and deliver a copy of this certificate of completion, marked defense exhibit number 1 for Jennifer Gonzalez. It would have been, I think, in February of 2026.
I've never seen that document.
Have you never seen it or you don't remember seeing it?
I've never seen that document.
Do you recall conversations we had regarding getting you in contact with the facility in the greenhouse facility up in Dallas, here in open court, not on any record, but just where I asked you, hey, what do you need? The judge, I think a couple of times, maybe asked you to get in touch with this facility and I'll give you information concerning that.
Yes.
And I don't want to beat a dead horse, but you're saying you never seen it, and you just don't remember seeing it.
I've never seen that document.
Because I'll call myself a witness and it's gonna be a.
You can't, I mean, really,
Really is, but and this might be a sticking point, but I don't know, I just,
you can't call yourself as a witness?
well, I mean, I think that as an officer of the court, I would have a duty to say what I actually.
Well, that's why you have argument. You can do it in an argument, but I mean, you can't call yourself as a witness.
I want to see witnesses subject myself to cross-examination by the government. I think that is allowed, but we'll see. I won't do it, but I'm just saying.
Yeah,
I understand.
not seen
I
that
understand you.
before.
That's all the questions I have. Thank you, Ms. Alder.
Do you, wait, hold on. Do you have any questions?
No questions from the state. Dominic.
Okay, thank you so much. You may be excused.
State rest, Judge.
Or defense rest?
No, Judge, I'm gonna call Ms. Gonzalez, Judge.
Okay. Will you raise your right hand, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Okay. You're a witness.
Ms. Gonzalez, you are the same Ms. Gonzalez who was placed on probation in this cause number that we're here in court today.
Yes, sir.
You have been presented and read a copy of the allegations saying that you violated the terms and conditions of your community supervision, have you not?
Yes, sir.
And to each one and every one of those allegations, join in singular, you are saying that they're not true.
Yes, sir.
Let's go back from the beginning and start. Did you attend the inpatient treatment center at the Greenhouse facility up and around the Dallas, Fort Worth, Texas area?
Absolutely, yes, sir, I did.
And did you successfully complete that program?
Yes, sir, I did.
Okay, and did you, as a result of that, get granted or given a copy of a certificate of completion?
Absolutely, sir.
Let me show you what's been marked for identification purposes as defense exhibit number 1. Can you identify what that is?
That's my completion paper.
Is this the one that you received at the time that you completed the program?
Yes, sir, it is.
Okay. Subject, any questions the government have, Judge, I'm asking that this be admitted into evidence.
Your Honor, lack of foundation.
Her certificate,
Authenticity.
her certificate, she received it, she knows where it's come from. I don't know if there's gonna be more that's gonna be needed, at least at this point, for this to be admitted at this type of hearing.
Your Honor, she could have got this from anywhere.
I quite agree. How do I know that's not printed out on a computer? There's no business. I mean, there's just, how do I know what's what?
I mean, that's fair. You're gonna have to go on her word that she did in fact receive it. And she's saying, yes, I did. And she successfully completed it. Okay. Going forward, how long after this, or you had a tragedy in your life that was reasonably close to this date here. What was that? Do you mind explaining it before?
We lost my father.
What date was it?
January the 8th.
So it was about 2 weeks after that you were allowed to
Be released.
release from the facility to come. In. With respect to these allegations, the first one says that you failed to report. And that you failed to report on October the 1st, 2025. And that you're not reported since then. Can you explain to the court exactly what happened with respect to number 2, paragraph number 2 in the allegations?
Like Ms. Luke said, I did report. I had a conversation with her that day. She asked me to have
Come to
somebody.
the court, I heard it.
She asked me to have somebody from the facility contact, and that's what I did. With them not contacting her is what she called me not reporting. But I had a phone call with her that day.
It was not an in-person visit.
No, sir, I was in Dallas.
Now, with respect to number 17, okay? They didn't mention the name on March 5th in this incident here, but they're saying on April 9th, they said that you tested positive and it was confirmed for amphetamine, methamphetamine, and opiates. Can you share with the court what that's all about?
I have Adderall prescription, well, at that time, Adderall and pain medication where I had broken my arm. And I had given those to pretrial. They have all those prescription paperwork.
What those, I guess you would know if they would test positive for opiates or for methamphetamine or amphetamine.
Speculation, Your Honor.
I have no idea.
So on number 21. No, she could testify on that. 21, you failed to participate in the year die victim impact panel by March 27th of 2025. Share with the court exactly what happened with that.
Honestly, Mr. Deloney, I didn't understand. That was, if anything, that was my mistake. I didn't know that I needed to still complete that. I was in Dallas. I was given a bunch of paperwork and said, here, go get your butt there and don't turn around. You got an hour to check in. That's what I was told.
Between November and March, before you went to the facility, were you in treatment in Baytown?
Yes, I was, sir, and I thought that was part of classes that I was supposed to be taking care of.
Were you in fact taking classes and other things at the facility in Baytown?
Yes, sir, it was for months.
From November to March?
Yes, sir.
With respect to number 22, okay? They're claiming that you failed to participate and complete within 180 days from November 27th, the DWI intervention program for repeat offenders. Share with the court what occurred there.
Well, once again, I thought the classes I was taking in Baytown were the classes that I was ordered to take. Because I was, with my knowledge, the teacher in Baytown stated that you are to take classes, it's here on your paperwork. Please be here by this time and this date so we can take classes. So that's what I thought I was taking care of it.
And with respect to number 24, the maintenance, which is now we understand that you failed to pay for that device. When you were released from jail to go to the facility, where was the device?
It was at home.
Were you able to go pick it up?
Absolutely.
Let me finish. Were you able to go home and pick up the device?
Absolutely not, sir.
Did you make any effort to have them send the device to you when you were up in rehab up in Dallas?
No, sir.
Did you make any payments toward the device when you were up in rehab?
No, sir, I didn't.
Were you able to make payments?
No, sir, I was in rehab. I had no job, no money, no anything. I was barely surviving over there.
Number 29, the failure to complete the rehab. You in fact did complete that, did you not?
I did, sir. Yes, sir.
In fact, you provided me a copy of that certificate of completion in February, shortly after you had completed the program.
Yes, sir.
Do you recall that I came to court with that certificate?
Absolutely, sir. You had a copy of it in your files that you showed me.
Did I happen to share with you what I may have done with that certificate once you gave it to me?
No, sir.
Okay, all right. Then I want to talk about something else that occurred. That on March, I think it's 15.
I believe it was 15.
You were arrested, weren't you?
Yes, sir.
You were arrested because this court had issued a reported bond violation for a preliminary positive test for drugs.
I was going to be arrested, July, but I did a no arrest bond prior to actually being arrested.
But there was a warrant that was issued for your arrest based upon that preliminary determination that there was a positive test.
Yes, sir. Absolutely.
Okay. And that test was on March the 22nd.
I believe, yes, sir.
Okay. The bond at the time was set by this court at $60,000.
Absolutely, yes, sir.
And then you came to court subsequent to that. And I wasn't able to be because I was out of town.
Yes, sir.
And it was determined by Ms. Mancias that the full testing of that turned out to be negative.
Yes, sir.
But you still had to go pay a $60,000 bond for something that was not true.
Yes, sir. Yes, sir. And then, yes, Mr. Lynn, sorry.
Yes, testing is not determined by. Testing is not determined by.
So, Mr. Knowles, are you referring to her?
I'm sorry?
Who are you referring to? About the veracity of a test?
Oh, no, the results were. I'm not so she determined it. The results came back after they did, I guess, a full count or whatever it was, and it was negative. It wasn't even positive. There was a preliminary positive. Let me call Ms. Mancia. She may be able to better explain that to us as to what happened, Judge.
I don't know if she's read, she can't just testify.
She testified to what she knows, at any point in time that she knows what she knows. If she doesn't know it, then she says she doesn't know. But at some point in time, there was a negative on it. I'm sorry, Judge, I'm asking her, and I don't even have the answer.
I mean, this is really just,
Your relevance to the motion. This is a test from March, which is not alleged in our motion.
this is true. Okay. Yeah, I guess let's stick within the confines of the motion.
Yes. Just,
Oh, I guess any further question?
no, I'll pass it.
Ms. Gonzalez,
Yes, ma'am.
you did have contact with your probation officer, correct?
Yes.
So when you got the certificate, you still had access to your probation officer.
At that point in time, I didn't have access to any, no, I didn't, because this just happened 2 months ago.
But you were able to share that with your lawyer, correct?
Yes.
But you were not able to share that with your probation officer.
I mean, I guess I could have if I didn't know I needed to. I thought my lawyer was bringing it to court as a show to the court.
So you could have shared it with your probation officer.
I could have, yes, ma'am.
Knowing that this was part of your probation conditions,
Yes, ma'am.
but you never did. And you never contacted your probation officer again.
I did not.
So this certificate, where did you get the certificate from?
There's a copy of my original certificate that was emailed to me from well, not emailed, but given to me from the greenhouse facility.
And what is the name of the person at this facility who sent this email out?
Miss Lori or Scott.
And so when you entered this facility, do you have any proof of attempts you made to reach out to your probation officer?
As in, we didn't have attempts to meet. I didn't attempt to meet her. We had a monthly scheduled meeting.
And you did tell her that you would be at this facility.
She knew I was there. The supervisor, the day that I went to the facility and checked in, the supervisor of the facility personally called and contacted Miss Luke and let her know that I was there checking. I recall she got his name, his information, and everything that she needed to verify that it was me being, or that I was there checking it.
And who did you talk to at the facility to communicate this information?
It's been almost over a year now. I don't remember his exact name. He was just a supervisor, a gentleman that was the main supervisor at the facility at that point.
In regards to community supervision, paragraph 21, the DWI victim impact panels. When you entered community supervision, you were told that you had to complete this condition, correct?
I was told that I had classes I needed to complete, not directly names or what classes, what was what, just you have certain classes you need to complete. And that's what I was aware of.
And were you given an opportunity to review your conditions of supervision?
When I was in,
When you signed the conditions?
I mean, yes, I guess, I was able to go home and review them.
And the community supervision, paragraph 21 specifically states participate and complete DWI victim impact panels.
Yes, ma'am, and I was doing classes in Baytown, and I was doing classes. So I could, once again, because it wasn't specified to me that this is a class that you need to pay for, it's gonna take something beyond what we're doing here in class in Baytown, then how was I supposed to know?
So, but you did know that you had to complete the 2 DWI victim impact panels.
I knew that I had classes I needed to complete. What the name of them were, I have not.
But you agree that it is in the community supervision paperwork, conditions that you signed, that you participate and complete 2 DWI victim impact panels.
I do see it in there, yes.
And you did not complete those 2.
Did I,
You did not complete the 2 victim impact panels.
because I didn't know that wasn't doing them already, then yes.
Pass it, Ms. Yara.
You gave me documents as you have many documents from me as your attorney, right?
Yes.
So you relied upon me to, as your counsel and advisor, to provide those documents to the people that needed to have them.
Absolutely, so,
And you gave those to me back in February, like we already discussed.
yes, sir.
And as far as you know, well, you don't know what I did with them exactly, but well, you do know, but
Yes, sir, I understand, yes, I'm sorry.
so. Here before the court, are you telling that you did in fact complete that program?
Absolutely, yes, sir, I did.
Councilman Schmidt.
No further questions.
Okay. Guess argument?
Your Honor, we heard from the probation officer that the defendant was placed on probation. She read her conditions, she signed her conditions, she knew what her conditions were. We heard that she had failed to report since October 1st. We heard that she tested positive on April 9th, 2025. We heard that she failed to attend the DWI victim impact panels, which she herself stated she signed it, that are in the conditions, which she signed the conditions for. She further did not participate and complete any of the DWI intervention program. She did not maintain her portable device. We heard from the probation officer that she did not communicate in any way that her device, that she could not pay for the device. There's no records of her paying. She did not maintain it in the proper way. Defendant also failed to attend the inpatient treatment program. Defense has given a certificate which was never communicated to anybody in this court, not to the COO, not to the probation officer. No one in this court has seen it before. It was never communicated to the probation officer that she completed these programs, and she has violated her terms of probation. Your Honor, the state moves to find the violations of the community supervision true.
Okay. Mr. Knowles?
Clearly, Judge, these allegations in their totality are not true, and the part of them that might even be like close to maybe a scintilla of truthfulness or so easily explained to the point that we don't have to resort to a violation of her Eighth Amendment rights under the totality of these circumstances. We don't have debtors prison anymore. And I think any kind of punishment exact for technical violations, even to the scintilla of one that they may have been proven, would be cruel and unusual. We don't want to put folks in jail for for this type of thing that can be fixed, my God, what we want to do is, okay, if we need to rehabilitate her, we look at it and say, March testing twice a week, and there's absolutely no dirties of any kind whatsoever. She is more than demonstrated that she can conform her conduct to that this court expects and what, in fact, the community at large would expect of us. Okay? Now, the finding of true of any of the allegations, followed by the imposition of a sentence of time in jail is not going to serve their stakeholder in this whole thing any good, I would submit. And I'm doing it humbly, I'm doing it respectfully. We both have seen allegations that are so much more serious than what's going on here. He has spent over 28 days in custody already behind these incidents or this incident. The most egregious one, though, is the one that I was talking about just a little bit ago, where this court saw there was a preliminary finding of a positive result, only to later find that it was in fact negative. By that time, the court had placed a $60,000 bond on her, which she then had to make, only to come and find out that it was negative. At some point in time, think about whether any of this is either true or is unusual in terms of the punishment that would be assessed in consideration of the child's circumstances. This is not the thing that's going to require more than the time that she's already spent in jail to I guess, satisfy whatever debt the court might feel that she owes the good folks of Harris County or the community at large. Jim, I personally don't see it having a value, even upon a revocation, even a finding of true of any one of these. Does it have a value greater than 28 days? Me think not.
Did it?
That's it.
I don't agree with you. Mr. Knowles, I think that we really bent over backwards to help Ms. Gonzalez. We did a TRAS. The TRAS recommended that she do inpatient treatment. I wanted to do inpatient treatment in our facility here in Harris County. At your request, we granted you the exception, because I don't like to do it, but we granted you the exception that she'd be allowed to do it at a facility of one that she would not be able to up and go. She goes to the facility, and how many times do we have that there was an allegation of it that she absconded?
At least twice that I know of.
The reason why we issued, and for purposes of the record, because you're making it seem like we're unfair that we had the bond at $60,000 just because we do it at will, but the reason we do what we do is while she was on bond, she had multiple bond violations while she's on bond for this DWI second. We, at your request, did that. She absconded from that facility at least twice. While she absconded, she never maintained contact with the probation officer. 2.5 years later, 2 years later, we're here back and we get this. I mean, really, we like to help people, but at some point when people want to do what they want to do at whenever they want to do it, it really violates the spirit of what the probation is about. And that's the problem we have here. We do what we do so that you don't pick up a felony DWI. That's why we have these programs in place. The programs are supposed to work how they work, not how you want it to work. And it's been like that the entire time. I think we've had to revoke her bond at least, I mean, how many times? And here we are at this time later. What's done? What got completed here throughout the probation? I don't even, what was, of all the conditions that there were, what got completed?
So Judge, indulge me if you would.
Sure, of course.
What is the value of this? What is the debt that now should be paid? What should we do to the Jennifer
Well, I'm gonna revoke her probation.
Gonzalez of the world? Clearly, revoke probation, and then we have to assess some type of punishment.
Sure, yes.
What is the value of that? What is it, a 20
So that
day?
you,
Is it a year?
so that
Is it-
you,
I mean,
well, number one, I will indulge you, but so that you learn that you can't just do whatever you want to do and expect good things to happen. When you're on probation, you're supposed to do what the probation officer says within the time allotted, not when you want to do it and then have other people after the fact. Okay, well, here we go, here we go, here we go, here we go. No, probation officer has set terms. We do TRASs for a reason. We do treatment for a reason. It's based on a curriculum so that you learn in the proper, it's like when you go to medical school. You go to medical school and you learn how to do medical school on their curriculum, not on your curriculum. Otherwise, what kind of doctors would we have? Black plague doctors who would bleed you just because they thought that was the right way to do things. Probation is a set term. It's a set way to do things, not what you want to do. What, in fact, what if anything was completed?
Judge, I have no proof that anything was successfully completed.
So I'm going to revoke your probation now. I'm going to find that the allegations are true. I'm now going to sentence you to 180 days in jail. I will give you credit. How much credit does she have? And I hope that this is a learning lesson, because when you get on this is not the Jennifer Gonzalez show. It's, you need to do what you need to do when it's ordered to do it. And okay, so we'll do 180 with credit. I'm going to suspend your license for 1 year. Do not drive until you get a license. And then, okay.
Thank you.
Thanks. Off the record. It doesn't make me feel good, but I don't want you to graduate to a felony status. That's what I want. And I don't care about anything else in this life, but understand, we don't want you to graduate to a felony status. And whatever we need to do to make that happen is what we do.
I just started school, Your Honor.
It's always, I got this, I got that, I just got this, I've just had a baby brother, I just had a death in the father, great. The law doesn't care what the heck just happened to you. When you get out there on the road, if you kill someone, they don't care that you just graduated. Okay, enough preaching. All right, thank you, Mr. Knoll. Hey, thank you for being patient. You ready? Are you here waiting? Oh, okay. Are we done?
31, was it CHA?
Just no, he just got here.
Judge, I know we called.
Set it for a week. I'm not, no, it's 2:30 now. We've called it until like 1 o'clock. No.
Yeah.
Bye, guys. Bye. Yeah, I'll be here Wednesday. Why are you here still? What's that?
I was just watching the.
Oh, okay. What is your last name? If you want to come up, we'll give you a reset. You can go.
All right.